podcast called The Steel Truth.
Okay.
Um, she's really big into the whole state national thing, changing your status and all this stuff. And I had to ask her, I said, well, what does that do? And what's that going to do for you? I'm just curious. I mean, if you get pulled over on the street and you flash something to a police officer, you really think that guy's going to know what any of that is? Or if he's going to say, oh, great, you're one of these nut jobs, and let me slap handcuffs on you and throw you in the back of my car.
Yeah, you know how many messages I got from people that use that stuff and they towed their car?
Yeah.
And then they went back to them and said, when they went back to them and asked them about it, they didn't want to bother with them at that point. So they come to me. I'm like, well, I can't do nothing about it. I didn't sell you the documents. I don't know what it is,
Yeah.
But it's, it doesn't work.
Well, I mean, it's extremely frustrating and sad at the same time. I mean, obviously, there's so much corruption within our government. I mean, that's just blatantly obvious. We know that. But the fact of the matter is there's no magic pill or piece of paper or document or any card you're going to get that's going to fix any and all of that. I mean, that's just the truth. So it's like picking battles. It's just like you say, Al. It's like, do I want to be harassed over not having a license plate on my car every 5 minutes because if I drive from one town to the next, to the next, to the next, or a different county? I mean, it's in their minds, it's all new. So pick your battles.
Yeah, that's so minor stuff. I mean, even though it's sort of like a shakedown, that's not your biggest battle. Your biggest battle is your property taxes, okay? That's where they're looting you, okay? That's where you're losing a ton of money. So to me, that's like Steve said, the guys that are messing with the driving stuff, that's like small scale to him. He don't worry about that stuff. He's worried about the big picture stuff, the property tax stuff, because that is life-changing stuff for people.
Well, it is.
They're pulling $10,000, $12,000 out of your pocket a year. That you could live a lot differently if you had another $10,000 or $12,000 in your pocket.
Yeah, I just helped. I think I called Brandon about this the other day, but I just helped a friend of mine. Well, actually, you know her. You came on our show, Nissa. She's got some shyster law firm in Salt Lake City trying to foreclose on her house, and they can't prove ownership of the title. They can't prove ownership of the deed, and none of this stuff. And they went ahead and foreclosed or doing a notice to foreclose. So Utah's a non-judicial foreclosure state. So all they have to do is just file a notice with the county recorder, and then they can set a foreclosure sale.
But they still have to have the originals, don't they? Every state, you have to have the original.
Oh, they do. They haven't been able to prove them. So not only that, the documentation that she's gotten from, so when she did a request for validation of debt, documentation that they've given her says that the owner of your loan is some like it's initials or something. I've never heard of it. It's like VRM, TGM, Elemental PQRS or what. I don't know. I mean, it's one of those weird type of places like that. And I said, this is who owns your loan. It's like, okay, well then according to the courts, they are the only ones who have standing to do this.
Right.
How is it that you're bringing this action against us? And so she's filing tomorrow a petition for a preliminary injunction in the federal court to get this to stop.
Yeah, well, I had issues with this 7 years ago too, and what happened was Bank of America sold my loan like 15 times. Now, if I knew now what I know, if I knew then what I knew now, I couldn't even, like your lady, she can't even make a payment, right? It's a lot different than people that just say I don't want to pay. I didn't even know who to pay, and next thing you know, I was like, well, screw it. I was already going down the path of getting rid of all my debt anyway, and I only had like 3 years of equity into the house, so I did let it go. But same situation, I didn't even know who I was supposed to be paying. And
they do that by design. I mean, Alphonse knows this, but like if they sell the loan and you haven't, or they haven't received a payment from you for 90 days, and they just turn around and just file the insurance claim on it, and they just get paid on the insurance. That's what happened with that friend of yours here in Pennsylvania, if I remember correctly.
No, we had me and Brett helped a guy named Harold that he made a deal with the original lender. They lowered his rate, and he had special deal with them. But then when they sold the loan, the new buyer decided they were going back to the old terms, and they started a foreclosure process against his house. They started to pull him in this foreclosure process. So we had a judge coming after him and an attorney coming after him. Well, I think somebody did him a favor, because when he contacted the original company that sold the loan, they provided him documents. And in the documents was a document that showed that they filed for the insurance company to get paid for the loss. So in other words, they already got paid for the loan with that document. They were paid for it. So it's like having a car accident, getting the insurance company to pay you, and then trying to squeeze the guy who hit you out for money, get more money from him. So here's what happened. What happened with that? His mortgage went away. Okay. That went away, and they settled for $350,000. And they actually flew a guy out. He got out in a car and, literally went in the house and wrote him a check for $350,000. And his father-in-law was a judge, and he was stunned because this guy was a lowly truck driver. He said the whole family, her whole family, or the wife's family, were all lawyers. So the father-in-law always sort of like looked down on him. He was a lowly truck driver, but he watched them bang that attorney and that judge around, man. He filed a securities fraud complaint with the SEC. And guess what the SEC said? We're going to look into this because he had the documents showing they were paid for this. Soon as they said they were going to look into it, they ran and settled with him and made it go away. Yeah. So that's what I think happens with a lot of this stuff. Like Brandon's saying, listen, when they sell your loan, I would be wondering if they actually got a settlement for that already or got paid for it, or if somebody's in default and they sell it. That's really where you want to look for it. If somebody's in default and they sell that loan, I'm wondering how many of them actually have already gotten paid for that by filing with the insurance company for a loss. And then the new guy buys it, and he's going to try and get paid for it too. That's securities fraud.
I think this is rampant, especially recently, where the government shut people's businesses down and people were unable to go to work. And so they would call their mortgage and ask for some type of forbearance, right? So by definition of forbearance is that you just tack on the extra to the end of the loan. Well, in my friend's case, she did a forbearance, and then at the end of the forbearance, they demanded all of that money.
Right.
And she says, well, I can't do this. And the next thing she knows, it's been sold to someone else, hence to what your story. So, yeah, I really believe these mortgage servicing companies, to them, this is the cost of doing business or the risk of doing business. They're like, we're going to go ahead and do this and figure that maybe less than 10% or even less than 5% of these people are going to know what we're doing and are going to be smart enough to put a stop to it. And the rest of them will go ahead and take their houses.
Well, it's risk versus reward, and we're seeing this all the way across the board. Okay, so you have lawyers and attorneys who have engineered a program of criminal racketeering at all levels to defraud us out of money, and this is why it's so important. Like Alphonse said, don't just assume. And we'll talk about this as we move forward too, because what we're going to do is talk about how to get information out of these people through records requests, that what we keep doing, right, and just asking questions, and what you get back is some of the most damning evidence. But you have to be patient. You can't lose your cool. You can't just make assumptions that the fraud. You got to find tangible evidence to prove what you're asserting. It's allege and prove, right? And then once you get to that point, then you write a pleading to go to court. And this is what we're telling people: there is remedy, and they're banking on the 99%. And I assume, and this is a theoretical position here, they're willing to pay to us 1% that figure it out. Oh, by the way, that this monkey, he figured it out. Go ahead, go on about your business, because the criminal racketeering by all the administrative agencies that are fleecing us like sheep on a farm, the rest of them are going to continue paying and playing the game. And it's unfortunate, but it's the truth. This is where we are because we have no intellectual awareness of how the game's being played. We're out here playing checkers, talking about straw men and birth certificates and things of that nature, and wondering why we're losing, right? Because nobody knows about that stuff. You take out, we'll go back to the original statement where I pull out a card and we assume incorrectly and ignorantly that the officer there pulling you over knows any damn thing. And that's the reason why.
I'm sorry. Here's the game. Here's the game. Listen, Steve got that big settlement, but that year they probably stole $200 million in property taxes. And how many years before that they didn't have no payout? So say they had 5 years like that. So there's $1 billion they took in property taxes. Oh, and they paid Steve's buddy out $38.2 million. Boy, that's a pretty good return, isn't it? $1 billion taken in, 38.2 paid out. Whether it's Wall Street, companies do this all the time. Banks do it. How many times have you seen a bank get pinched on Wall Street? Well, they stole $2 billion and they got fined $200 million. Well, that's a hell of a return, And they're doing that with us too, because they know that mostly we're monkeys, and how many times they hear, I'm going to sue you. Yeah. Go sue me. Yeah. Okay. And they're not used to people suing them.
Yeah. So, by the way, I do need to just clarify. I did talk to my friend, and she told me I have her permission to share her story. She wants to help others, and she's a fantastic individual, great woman, a great mother and wife, and she's just as fed up about all of this as well. I mean, I was telling Brandon about this the other day. Is like, listening to her story just makes your head spin. You're like, okay, hold on a second. So you took a loan with company A, then it was sold to B, C, D, and E, and now F was sending you statements, but then G is now sending you statements, and now I is involved too. Who are these companies?
One party's got to have the loan. How many people have their hands on the loan?
Well, it was like, so when she did a request for validation of debt, the company that says they're servicing the mortgage, they provided 3 different companies that have to do with this loan. I was like, oh, well, I'm still confused here. Who actually owns this loan? I mean, not only that, I mean, that's aside from the fact that looking at her actual promissory note, there's no transfer clause. There's no assignability clause in the promissory note. That's a whole nother issue. But even still, we're just trying to take care of this issue right now and get ahead of this.
Did you ask for an accounting of the payments? I'd ask for an accounting. I want to see, like, somebody's got a list of the payments where everything stands. I bet they couldn't even put that together for you. Okay.
Well, they can't. So again, she asked for that. So what does she get? The accounting statement from the existing company that says they're the existing servicer. Nothing prior to that. So we have no clue what's happened prior to that. So how is that any validation of anything? All you've done, and then you have these stupid shysters.
What if she said, "Hey, you know what? I overpaid the loan with the previous people.
Exactly.
Where's that money at?"
Exactly. So then you have these stupid shysters that are saying the federal law only requires us to do this. It's like, really? I'm gonna have some fun with you guys. We're gonna rake you guys through the freaking coals by the time I'm done with you. So
it does get fun, and I do want to why you make that statement.
Mm-hmm.
Guys, and what this chat is, let me explain to everybody here that's going to make this deal. What we're going to do is talk about our each individual's current trajectory in dealing with each of our separate cases. Look, when I've got a property tax issue, I go to Alphonse because Alphonse is directly involved with property tax issues. There's no way we can all know everything in every situation. I don't expect anybody to know how to deal with the Mississippi Band of Choctaw Indians or any other Indian organization. Okay, it took
you're the Indian expert now.
It took me over 5,000 pages of reading to even compile a pleading on this particular issue. Okay. But at the same time, the same principles apply in each case, right? Where's the proof? Show me, okay? And if you can validate your claim, you can substantiate it with evidence that can be admissible in court, which includes affidavits and depositions of firsthand witnesses and testimony. We're going to get through this because the Rule 50, I think it's 56, James.
Yep.
Rule 56 is important if you're in federal court, okay? It's very important. I'll tell y'all right now, Gary and I, on Gary's particular case of the theft of his motorcycle, we're putting in a default judgment on the tow truck company. They never answered the complaint. Boom, win. It's a win already. All right, second thing. We have been psychologically trained to believe that these lawyers know what they're doing. That's not the truth. It's the lawyer for the city of Central who is representing the mayor of the city of Central and the police of the city of Central in Gary's case did not file one motion. He answered the complaint, gave us a complete answer and denied every allegation. Gary sends him the status report yesterday. Listen, he didn't even read the complaint. This is important because this is how idiotic these people are. Gary sends him an email yesterday, and I told Gary tonight to write the motion in limine to include evidence. He writes him an email and says, "Oh, by the way, you didn't even ask the chief about the video that was taken. You have video. You just denied all allegations." Okay. Now listen, during this traffic stop that we recorded 2 years ago, it's taken 2 years to figure out to do this. They actually wrote tickets to someone else that owned the previous owner of the bike, okay, which was fraud and forgery. That allegation was denied. So we have an estoppel here where here's the problem we have, and I was thinking about this with Gary. Do we even call out the fact that there's no affidavits or depositions or firsthand testimony, or and call that out? Or do we continue to allow this idiot lawyer to continue to dig the hole and deny everything? That way he can't move from his position. And see, this is a tactical thought, because it's like Dr. Graves teaches in his course, right? Do not object when they're helping your cause.
Yeah.
Okay.
That's Sun Tzu 101.
Does the videotape contradict a lot of what the
everything. So he's out here making these blatant denials of all allegations, and answered the complaint instead. At least the New Mexico law firm did try to send a motion to dismiss to Rule 12b-6, right? But they can't dismiss it. There's no affidavits or depositions in the record for them to actually dismiss it. I agreed to the oral argument, so I'm waiting to go to Jackson, Mississippi on that issue. And then Alphonse had a wonderful episode at the had fun with the municipal corporation the other day. And look, guys, the purpose of this tangent that I'm going on, knowledge really is power. Okay. When you wield the primary virtue that we're talking about, which is truth, okay, not some delusion that some internet gurus have taught you. We've all had to go through the idiot phase. Okay. We're applying law as it is written, black and white. Find what you need. I'm right now reading a 300-page essay on the wildlife and fisheries, because I got a lawsuit coming up that is just it's a beautiful win. Here's another issue. Gary and I've got the mediation for my daughter's Oshner group next week.
That's going forever. Where's that at now?
It's next Wednesday is the mediation for my daughter. It has gone all the way to mediation. So we're almost done with that. I printed my daughter a 300-page book. She contacts me every night. What about now? She knows they violated her rights. So it's been a good process. But we've got the City of Central Police lawsuit, Mississippi Band of Choctaw Indians lawsuit. Now I've got a lawsuit against Wildlife and Fisheries for the illegal trespass. Now, let me tell you how stupid the agents are. Why you don't argue with the people in the field. A private person, okay, and we'll do this. A private person engaged with state actors in the deprivation of rights under color of law is by what? He's a state actor. Okay, so I had a private person trespass my property, search my property, call Wildlife and Fisheries. Wildlife and Fisheries executed a warrantless search and seizure of that property and assisted the criminal trespasser right there in front of him.
We don't need no stinking rules. We don't need no stinking rules.
Listen, and what it is simple. You can't get admissible evidence by illegal or unlawful means. Okay, they can't even bring up anything in the administrative process and say, oh, by the way, we were just stopping by doing a wellness check on your place. No, you didn't. Yeah, I've got the record of who reported, and you aided and abetted criminal activity right there in front of you. Now they're under no duty. Make no mistake about this, folks. You see all this crap on TV about Uvalde and everything else, and people are all up in arms. Police are under no obligation to ever assist you in your safety. They're not. Okay, no. Just know that it's not part of the due process.
There's actually well-established court cases that state that the cops have no obligation to protect you.
Right.
Okay,
that's right. So each one of us is going to go forward and in just discussing the different trajectory. I think, James, you've moved on. You've caught your in your particular case in Utah, you've caught correct me if I'm wrong on this. James has caught the Attorney of the Year for Utah in perjury. Okay.
Yes.
Okay. And Alphonse gets to go and have fun with these municipalities. And look, folks, I know it's a daunting task. I know it is to read and research, but you have Randy Kelton's group, Dr. Graves' group, James has a group. Alphonse has a group. I have a group where we post all this information. Unlike us, us guys who had to go out and grab it first and start paying. I pay for Westlaw, and I give every damn case law asked of me to anybody who asks. It's at your fingertips like never before, and it is fun. It becomes very fun to catch these people in their lives, because I'm going to tell you, because these ignorant people in their arrogance and hubris are going to double and triple down in their stupidity with losing hands every time. It's without fail. I've given another good faith effort. I tell you what, I even went so far, and I'll stop and I'll give the floor to you two. I went so far as the man that originally trespassed my property, because down in the swamps, my dad has sentimental value to this property. That's the only reason I sent out a good faith notice. Called the man. And I said, Dwayne, I'm going to try to save you, job. And I got a tirade of F you son of a bitch. Because he knew I had him caught. But instead, because he's got a childlike mind and I outwitted him, he's mad and angry. And the only thing he knows how to do is throw a childlike temper tantrum. And I said, and I had to go, well, I'm sorry, Dwayne, but now I'm going to get you a damn job. I offered you this olive branch because this place has sentimental value. It's been in our family for over 70 years. Okay. And so it has sentimental value to my dad. It's no reason I'm being nice to that, and I have too much to do right now. I'm going to slow play this.
You want to delay. Yeah, you got to delay. At a certain time, you want to delay, you know. You want to knock them out. It's another time to do it, you know.
Yeah, there's no way I've got time to do this right now. All right. With that said, I'm going to go get some water and take off James or Alphonse.
Now, one other thing real quick, James, I'll say the great thing with the groups is, like the other day I did a post to Dr. Graves just as a response to show him how administrative courts are set up and how judicial courts are set up and what they're actually doing to us, okay? It's nothing to do with straw men and this and that. They're just basically running the average man through an administrative quasi-judicial court. And when you go in those quasi-judicial courts, well, they're basically waiving due process, and they're waiving trial by jury. Well, you and I know that you can never waive due process of law, and you can never waive trial by jury, because in the Pennsylvania Constitution, it states that trial by jury is an inviolate right, which means permanent, can't be taken away. So I can't go before an administrative court, quasi-judicial court, and have the judge tell me, well, you're not entitled to a trial in this matter, which has happened to me. Where I actually had a judge tell me, you're not entitled to it. Really? Let's go talk about this in federal district court. And now you, Mr. Judge, can tell me why the state and federal constitution don't apply in your court.
Yeah.
Now you turn around and say, well, this is an administrative court. Because the only way I can beat an administrative court is if I am under contract with somebody. If I don't have a contract with them, I got no right being in that court.
Exactly. You know, people don't realize too, to add to your point there, Alphonse, people don't realize too that these quasi-judicial courts, sometimes they operate all on their own. I would call these like your small little municipality courts. Those are strictly quasi-judicial. They don't do anything that's remotely close to a judicial court of record there. However, when you step it up to the next level, I don't know how it is in Pennsylvania or down in Louisiana, but in Utah, we have, the district court, and we have the appellate court, and we have the Supreme Court, very similar how the Fed is set up. Even those district courts, 90% of the cases that run through those courts are quasi-judicial administrative cases, 90%. And something that I was listening to a while ago that hit me like a ton of bricks, and Alphonse, I'm sure you can appreciate this. You guys both know who Richard Cornforth is, correct?
Yeah,
you've heard of him. So he's also put out a number of seminars. I mean, he did this a long time ago, back in the late 80s, 90s, I want to say. And he mentioned, the one thing he said that hit me like a ton of bricks was the court's jurisdiction is only gained by the sufficiency of the pleadings entered into it. So what does that tell you? Well, that tells you two things. One, if you're being dragged through an administrative court, then you need to look about exactly how you got there. Was it from a citation? Was it from an information, whatever the hell that is, right?
Yeah.
I mean, what can somebody please point out to me where it says in the Constitution that I can be prosecuted with an information?
It doesn't.
Because it doesn't. Okay, it's very clear, especially when they say, "Well, this is a criminal court." Oh, is it now? So now the way that I read my Fifth and Sixth Amendment rights is that I know that I cannot be prosecuted criminally unless I'm presented with an indictment.
Right.
I don't have an indictment. All I have is an information, which alleges these quote unquote felonies where there's no complaining victim on the other end. So this is what people need to realize is that court has now stopped. They've taken off the Article 3 court and set it to the side, hat, right? Now they put on their administrative hat and they act as if it's a court of law according to the Constitution. And they expect you to act as such. And so when people actually stand up and say, whoa, 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 this is not anywhere close to what it should be. Not anywhere close. They will do one of two things. They'll either tuck tail and turn and run, or they'll double down. If they double down, they're the dumbest idiots in the planet because you can take them for everything we got, which we're doing. So
yeah, and to clear this off for a lot of people that don't understand what we're talking about, we're talking about judicial and quasi-judicial. Listen, there's a place for quasi-judicial courts. They were created by the legislature to deal with company fighting company, okay? So it was a shortcut process to clean the courts out. That's all it was, really. That's the purpose of a quasi-judicial court. So if the township is fighting the sewer authority, they can hash it out in this quasi-judicial court because that court is run strictly by statute, okay? Think about it. The entity are all legal entities that court's made for. Legal entities are organized and incorporated under the state. The way the Congress controls them is through statute. So that's why there are no rights in that quasi-judicial court, because how the hell does a corporation have a God-given substantive right to live somewhere or to own property? They don't, okay? All their rights come from statute. That's why when you're in these little quasi-judicial courts, they don't care about the Constitution. They don't care about due process. They're following strictly the statute. If this idiot attorney drags you in under the municipal claim and tax lien law, that's the exact statute in that court they're operating under. They don't care about anything else outside that. They're going to work from that. So your goal is to stay the hell out of that court so that you're not dealing with that municipal claim tax lien law. And the way you do that is you turn that quasi-judicial court into a judicial court, which you and I know they can't be, but you're stupid. You're Columbo. I don't understand. Hey, I'm going to file a motion here to strike this or a motion to dismiss because I was never given service of process. Okay.
Yep.
I was never, was never given afforded an opportunity to defend myself. You guys made a judgment. A clerk made a judgment. How's a clerk issue judgments? They can't, but they can in a quasi-judicial court because the statute says the clerk can issue a judgment. Now, you and I know in a judicial court, that's an impossibility, okay? Only the jury can issue a judgment. That's it. So you got to separate that. If you get anything in the mail from somebody saying you owe them or you have this hearing, you're in a quasi-judicial process. If you get a process server knock on your door and serve you, you're in a judicial court. That's how you can separate it in your mind. Comes in the mail, I'm in a quasi-judicial process. I get a process server show up, I'm in a judicial court, okay? So when I get that mailing from the quasi-judicial court, I'm going to play stupid and go, hey, wait a minute, I don't understand this. I'm looking here at the Pennsylvania Constitution. I have a right to trial by jury in all matters. That's an inviolate right. I'm going to demand that. So if you're not going to provide that to me, then I'm not going to show up to that hearing. I just did it recently last Friday, and I'm sure he probably put a warrant out for me. And Mr. Judge is in for a surprise because I just wrote criminal complaints up against him and the code enforcer. That's going to go to the state. Now, here's what's going to happen. I mean, it's going to go to the county. I know the DA is going to run cover for them and say that there's no probable cause here. No problem. When I get that back from the DA, I'm then going to take my criminal complaints and I'm going to ship them off to the special agent in charge of the FBI. And I'm going to send them to the feds. And I'm going to go, hey, this is not about a little citation, this matter. This is, like Brandon said, this is federal racketeering, okay?
Yep.
Doing this, tens of thousands of people. Now, here's what I discovered, James and Brandon. I was stunned. I actually went through and read the citation law here in Pennsylvania. Well, guess what? Here's what I found. Like, Brandon, you know this. If the statute doesn't, if it enumerates things in the statute, you're locked to the enumeration of the things. If they say who a law enforcement officer is, it's a sheriff, a deputy sheriff, a detective, you're locked into that. Nowhere in there does it say code enforcer. Okay, so when you read the citation laws, here's what it states: if he's not a law enforcement officer, which the code enforcer is not, guess what he's got to file, James? He's got to file a complaint.
Yeah.
He can't use the citation. Even under their statutes, only a law enforcement officer can use the citation. If it's anybody but a law enforcement officer, he's got to file a complaint. And then guess what the judge has to do, guys? He's got to determine probable cause. I'm looking at this complaint. If it's valid, it states the judge must issue process, which means he's not going to take that complaint and send a summons out with it to give you a notice and opportunity to defend yourself. Guess what? They're not doing that here. They're not doing it to where you guys are at, okay? They're taking a citation written by a non-law enforcement officer, and they're treating it like he's a law enforcement officer. How many tens of thousands of people have they done this to? How many hundreds of millions of dollars have they stolen? Breaking, I mean, it's blatant law sitting right there. So guess what? To me, that's federal racketeering.
It absolutely is.
Yeah.
No, I mean, that's got RICO written all over it. And the only way, and I hope everybody watching this gets this, because this is why Alphonse is so passionate, why Brandon is so passionate, why I am so passionate. We're only three men. We can't do this alone. As much as we would like to, we can't. So we have got to do what we can to share our knowledge with others, to educate others, because I can tell you right now, if more of these federal RICO cases start filing up in these federal district courts, someone's going to take notice. They've just been getting away with it for so long. And I can tell you right now, the bar is the problem. The Bar Association is the problem. Any one of those morons that gets one of those cards that says, I'm licensed to be a lawyer, they can shove that card where the sun doesn't shine, because I already know more than those morons do. And I haven't spent 1 minute in a law school classroom.
It's pretty sad too. And once you see it, and I'm just going to read this to you guys because it coincides with what both James. This is my latest letter to the director. Now, mind you, the Director of Wildlife and Fisheries is not a state law enforcement agency, even though they act like one. They are commissioned under the executive branch of government. Okay. So it just to show you, because we're going to talk about language and what the importance of language is and how to use language to invoke like a Monell claim, or I think it's Smith versus Ward, where you invoke punitive damages. Okay. And it's important to understand this stuff. And I'm just going to read a piece of it. Okay. The continued level of ignorance and outright incompetence at all levels of this flagrant abuse of power is both reckless and callously indifferent to my rights, as secured by the Constitution of the United States and the Constitution of Louisiana. So let me explain that language to you. Guys, it is a word game out there. People saying it's a word game, but they're misconstruing it. They're going off into la-la land. They don't understand that it's the correct placement of words in context that initiates a claim, okay? What I just claimed here was that they're liable for punitive damages. Now, some lawyer somewhere might read this and understand this, but right here is the Smith versus, I think it's Smith versus Ward. It's the language that's needed for Title 42, 1983 punitive damage reward. So let me help you guys. Remember the case law. Remember the language. Arbitrary, capricious, and unreasonable. Okay, that I know the case law that goes to. The lack of training for employees under your authority. I know that's the Monell claim. Okay, I know this claim right here is the Smith versus Ward. I understand the Civil Rights Act of 1871, and we use this language over and over again, and especially when invoking your constitutional rights. That's why we give you the American jurisprudence. Okay. That way you can pull directly out of it and start putting it in your case. Wildlife and fisheries agents know or should have known that evidence gained unlawfully and illegally is inadmissible in a court of law. Wildlife and fisheries agents know or should have known that trespassing of property by private actors engaged with state actors in the violation of I should have put constitutional rights is a federally pursuable civil case, as well as an easy district court win in Baton Rouge, Louisiana. The ignoring of the records request while hiding behind the vague statement of criminal investigation, while openly ignoring the warrantless search and seizure of property and engaging with private persons in the deprivations of rights, while acting under color of law is reprehensible at best. What is more concerning is that my extreme level of competence regarding these legal and lawful procedures, without it, I would have been another victim of criminal racketeering by agencies of the state with zero regard for the rights of the people. Since the director can be sued and can sue, it may be in his best interest to contact me. And now, look, guys, I just want to show you how you stack on top. And this is just a few, okay? I haven't even really started investigating this yet. I've only interviewed. And listen, Alphonse goes to the municipal courthouse. He starts talking to these people. What these people will say is some of the most important evidence that you can get. So I called the director. I put records request in, and what I get back, I have wildlife agents come out to my house. One of them actually was an honorable man, Mr. Randy Lanou, and I'll show you at the end of this. I actually put a compliment in here for him. Okay. And then I started calling everybody involved. And what happens with people of low intelligence? They start bus chucking and they start tattletelling. You got to catch this stuff. You're putting stuff together. So what we have is the original trespass of property. Okay. We have the conspiracy because Dwayne Crawford called Wildlife and Fisheries, right? That private person now is engaged as a state actor in the deprivation of my rights. We have the warrantless search and seizure of property, absent of an affidavit of probable cause. We have the unlawful conversion of property belonging to me. Then we have the negligence by trained officers. So I've got my Monell claim already, and he may not even understand what I'm doing, but I'm setting it up, okay? And I'm doing this communication back and forth. All this, you'll see right here. I put this right here. I put it, I am sure that we can come to an agreement without me filing an actual lawsuit against the director, since he is solely liable for the training of his employees. And he is.
You always, Steve said, you got to stress that it's improper training. You always want to get that in your pleading.
Yeah, and see right here, I met a great officer of the state. Okay, I did. I do have one pleasant report. Sergeant Randy Lanou is an honorable man and one of the best agents of the state. I'm going to tell you, he gave me every piece of evidence I asked for willingly. I'm just telling you guys, if you learn to play the rules of the game better than your opponent, you will win. Mm-hmm. It's going to happen. Mm-hmm. And learn to be tactful. I didn't have to call these people, cussing them out. I just put it on paper. There's a paper trail following me. As soon as I made a phone call to Dwayne Crawford, he went nuts and told me that my property was his and he had lawful authority to do whatever he wanted. What did I do? I instantly made a timeline of events, including everything that he said, and shot it out. Right? Look, it's amazing what you can get out of these people. Lower your emotions. Think it through. Think tactfully, and methodically move through these people and make a record. If I was trying to help some lady the other day, and y'all know this. Well, what happened? Well, hold on. Let me think about it for a second. No, write everything down. Everything that you doesn't even think matter. It may be the pivotal point in your case.
Mm-hmm. Yeah, listen. When me and my buddy Carmen went to the tax bureau yesterday, and I had butted heads with this one woman, and like Brandon said, I said, let me take a different approach here. I'm just going to do a Columbo here and just say, hey, listen, I just need you to explain this to me. I need to understand this upset sale process. How does this work? If I'm the high bidder that day for the property, what do I leave with that day? She said, well, you get a receipt. I said, okay, but what's going to be? Yeah, I get a receipt. So he said, so what about my evidence that I own the property? She said, well, it'll take us a few weeks to make a deed up. Oh, so now we got securities fraud. Now we're making deeds up on people's property. Okay, I said, I understand. I said, but so I said, I'm just trying to put this together, and I'm doing a Columbo, dude. And the older woman, when I first started dealing with, where she said, when I asked for basic records, she said, I never had to do this before. She's been there for like 30 years. I mean, nobody came in here and asked for these basic records. Dude, she was all flustered and mad. She said, the old woman says to the tax sale person, I don't think he understands. I said, dear, I understand fully. I'm just trying to get information. I don't think you understand. So I said to her, I said, well, what about the title? She said, well, I can't get your title. And I'm thinking, well, you're willing to forge a deed. Why not forge a title? You know? She said, I can't give you a title. I said, so let me get this straight. So you're saying you're going to sell the property without title? And she sees me like smiling. She know what she said to me and Carmen? She said, buyer beware. And we looked at each other like, did she just say that? So let me get this straight. This is how we always sell property, land in the U.S. Because when you go to buy it from the seller tells you, hey, Brandon and James, buyer beware. I'm selling it to you, but the real owner might come back and he might take it back and you might not have anything. Oh, and by the way, you may get sued and lose more money than what you put in. So
yeah, there's a word for that, Alphonse. It's called fraud.
Yeah, it's fraud. Buyer beware. I just, my jaw dropped. I went, my God, like, how does that not tell them that this is not a legitimate sales process? Because if it was a legitimate sales process, there'd be no way to come back to get the property, okay? If I sell property to somebody, nobody can nullify that sale. It's my property. I could sell it. Doesn't matter what the previous owner did. I bought it from him. But if I'm selling property to you, Brandon, and I say, hey, Brandon, I'm selling it to you, but hey, listen, buyer beware. Maybe 5 years down the line, this guy might pop up with a lawsuit.
And I'm going to go. I'm going to go. How hot is this?
I wonder if Fonzie did the same thing when he was running his schemes. Like, hey, buyer beware.
Yeah, it's like a guy with a trunk going, hey, come here, look what I got here. Hey, look, I got a house right here. I'll sell it to you. You know, buyer beware. And I went, wow, just the arrogance of that. Like, but herself, how could she not have the mental acuity or interest to find out? Why would I say buyer beware? Why can somebody come back and get the property back? Why would the original owner be able to come get the property back, which happened in Steve's case for his buddy? That house was going for 3 or 4 years, and they got it back, okay? So this is the level of ignorance you're dealing with these people. So like Brandon and James said, listen, don't argue with these people. They don't know what they're doing. You're wasting your breath. You're wasting your time. Just get them to say the dumb things. Ask the basic questions. Brandon said, note it, you know, hey, so-and-so told me buyer beware, you know, because that looks great before a court that, hey, listen, we're selling property, but you might lose it because the original owner might come back and actually claim his rights. Well, and you shouldn't be doing what you're doing.
And that phone call to Dwayne Crawford while he's cussing me out, he's sitting there telling me he has every right to go on my property. He owns it. Continental Land and Fur owns it. And when he goes and searches that property, it's his duty. For Continental Land Fire, I said, sir, you're sadly mistaken. I pay you to lease that property. You're not law enforcement. And I said, by the way, do you own any title to that property? And he thought about it for a second. I said, I'm the sole exclusive title holder to that property. Yeah. I said, you didn't have my permission. There's trespass. They're literally, guys, I bought the trespassing signs that say you will be prosecuted for a reason. You know, I didn't buy the just no trespassing signs. It says you will be prosecuted, right? And they're all around the property. And that's when he started. Oh, did he cuss me good then? You look, and I'll show people here in a minute. And I don't have to. I'll just tell you. So I tried to save Dwayne Crawford's job. Okay, I was willing to settle on account of this is my dad's heritage. It means more to him. Dude, it'll take me 3 hours to go get another lease somewhere down there because nobody goes back there anymore and just drag my houseboat over there to it. But it means something to my dad. Okay. So I was willing to save this man's jobs. Called him up. He knows he's been caught. And I start off the conversation. I'm sure you know by now there is no criminal investigation into Brandon Sibley because there was no criminal wrongdoing. But there is criminal investigation into your trespassing my property. And it just blew up from there. But nonetheless, what happened is that through his anger and animosity, he told on himself. So at that point in time, I just had hearsay, right, and little details that I got to read. But he told me point blank that it was him that went on my property. And that's big. That means it's in the full report. That means there's going to be other evidence leading up to that I can get. That means there's going to be emails, text messages, and everything else that I can subpoena and get a hold of. And you have to understand this, folks, because ignorant people run their mouths. They do. Alphonse knows this in his records request with the emails. James is finding this out. When you dig for information, these people are so incompetent and so damn arrogant because they're so used to running over you and I and the regular people in this country that they openly talk about it. Hell, you watch the TV with the politicians and everything. If you just watch 5 minutes of it, you got to go, this is clown world. You know, and just go, hey, these people are insane. But they are. They'll double down and triple down every time on their insanity.
Yeah, you hit on something real important. And let's clarify this. People don't understand property ownership. Listen, there's only two types of property ownership in the U.S. There's absolute and there's conditional. Brandon has conditional ownership of that property. In other words, they own the property, but he's got a lease on the property. He has conditional ownership until that lease is up. It's his property, okay? If he bought it outright, he'd have absolute ownership of it, which mean he would have a allodial title to it. So you don't have to run and get like an allodial title. People think, I got to go get the land patent. No. Land patent has nothing to do with allodial title. You can only own property in the U.S. allodial. The people that own that property that Brandon's leasing, they have allodial title to the property. Brandon has conditional ownership of the property because he has a lease with them. But the actual owner of the property always has absolute ownership of it, and he has, by definition, a allodial title. You don't have to jump through hoops and do cartwheels to get a allodial title of your property. And you don't lose ownership or rights in your property when you register it. Here's what the registration process is for. Now, the counties have taken it and bastardized it because when you register your property, the assessor goes through the properties and goes, yep, taxable, okay? And they start sending you tax bills. Well, that's basically document fraud. He's falsifying tax records, all right? But I lost my train of thought. See what happens when you get old?
Well, it's okay, and you're going there, but and you're right. So I pay a fee to use the land, yes. And in that contract, it is stipulated my duties and obligations to the absolute owner. Okay.
Oh, that's it. Here's what the registration is for. It was to stop land disputes. It's so that somebody can't push me off my property and take my documents and go, well, I own Alphonse's property now. No. I got it registered with the county. Look, I got the records on file. It's my property. That's all registration's for. It's not to grant ownership or rights or interest in property that you own. Whether it's your car or whether it's your home or your land, you don't lose ownership in something because you registered. It's the dumbest thing I've ever heard. Yet it's a prevalent thought out there. My God, I cringe when I see people talking about that. Well, when you register it, you give ownership away. You give no such ownership away. You don't give ownership, interest, or rights in the property away. You give nothing away. Just because some idiot from the county goes in there and tampers with the record by changing it to taxable, he never had rights to do that in the first place. And this is where you take them down when you sue them in federal district court. Nobody's coming in that court explaining how when you registered that property, well, they decided that it was a taxable property. Well, how can it be
with a
taxable?
situs and a nexus.
Right, right.
Yeah, that's one of my favorite lines that I learned early on from you, Alphonse, is like, well, what evidence do you have in your possession that proves beyond a shadow of a doubt that I am operating my property as a citizen?
Yeah, I mean, it's really no more basic than this. It's people have complicated it. Do you have a right to own property? Yes, right? It's right there in your state constitution. You have a substantive right to own property. Can you tax a right? Can a right ever be taxed?
No.
So then how can they tax the value of that right? So you're going to charge me now I have a right to own the property, so you're going to charge me a tax on the value of that right. Because my property might be worth $400,000.
That doesn't make sense.
No sense whatsoever. The
you know,
basics. I'm saying, good.
Sorry, I didn't want to cut you off, Alphonse. You know, these people are just it boggles your mind, the level of incompetence. And if all of you listening, you've all dealt with these people who work at I would call them the front lines of any one of these state or federal government agencies, right? Just these are the people that you interact with on a day-to-day basis. They're only told to do what their policy manual says they should do. They don't have a clue what the law compels them to do. They don't have a clue what rights are being violated in the course of them doing their business. They just do what they're told to do because their boss said to do it. So it's just like Brandon said, you've got to hit on the head. Your training is wholly inadequate. And that rests with you, Mr. Director or Miss Director. That sits with you. So this is something I want everybody listening to write this down. This is a doctrine known as respondent superior. Respondent superior. What that means is you can sue that organization and the organization's head for the lack of competence of any of those employees. And that's a fantastic one to do. So the second thing I wanted to add to that, Alphonse, is those people are incompetent, but then the people who are supposed to know the law, these supposed attorneys, these things make your head spin. I want to read a line to you. I filed a motion for sanctions in my case against this attorney for lying to the court. And she came back here and had some pretty brazen things to say. It makes me laugh. Again, words have meaning, right, Brandon? Words have meaning. The specific words we use, right?
That's right.
So let me ask you guys this. So in my complaint, I wrote the alleged new virus. Alleged virus. Does that give any ambiguity whatsoever?
No.
I mean, well, what is this alleged? I don't know. So in the response to everything that this stupid liar did, she just took out alleged virus or alleged new virus and just replaced it with COVID-19, thinking everything was fine. She says here in her opposition to my motion for sanctions, I'm just going to read a couple things here. She says plaintiffs referred to the virus many times. This is again, she is still lying to the court because she put plaintiffs referred to in quotation marks the virus. If you read my complaint, I don't say anywhere in there the virus. It says alleged virus or alleged new virus. And I was very meticulous about that for a very specific reason, because I can't prove that it exists. And if I can't prove it exists, I'm not going to say that it exists and give that upper hand to my opponent.
Right. And in your defense in that too, it's a moot argument, right? I posted that directly out of American jurisprudence really recently with all the case law that backs that up. And if you need it, I'll send it to you again. And the reason for that is without any physical, tangible evidence, it's just an abstract idea. And that's the direct reading from the case law. And it goes from there into birth certificates, the straw man theory, the free man, and that all the free man on the land, but it goes through this whole plethora of moot objects. So without any physical, tangible evidence that the court can admit into the court, it's just in the land of abstract ideas. Okay, and this is how this system operates. Now they're wanting to push that. And this is why we have to defend it, because this adversarial system is the best system possible by man. That's my opinion. Okay.
It really is.
It's a very strong opinion because an educated society can walk into any court. We're not talking about that you have, and Dr. Graves is 79 years old. I want to discuss this right now. and we've done the 1895 Kansas exit exam. 70 years ago, when Dr. Graves was right, his education experience doesn't equate to ours or mine or the younger people here who don't have any education or any ability to write, plead. If you cannot write well, you cannot think well. If you cannot think well, others will do the thinking for you. That's George Orwell's Animal Farm. Okay, so that's why the systematic reduction in our ability to use English precisely with precision language. Right, I'm gonna pinpoint on you. I'm gonna dial in on you, and I'm gonna start hitting you with these grammar darts, and I'm gonna pin you into a hole. And that's why we go through all these children. All right. We're writing these complaints, and there's going to be an adult in the room that we're going to eventually meet. It might be on the appeal process. You're going to find an adult somewhere that goes, come on in. Come on in.
Yeah. And to your point real quick too, I just wanted to finish with this, and that this stupid attorney. Now, Brandon mentioned this earlier, okay? My adversary that I'm going up against is a member of the Attorney General's office here in my state. Not only that, she was also named the Utah Bar Association's Attorney of the Year last year. So you would think that she's got to be pretty good. So let me read this to you guys, and you tell me what you think, okay? There's a few things I want to read here.
Can I give the screen to you?
What's that?
Can I give the screen to you?
Yeah. Let's do that.
How do I do that? Do y'all know?
Great question. I don't know. I think you have to do it in your settings.
Let's see. See if I can add you to.
Oh, you know what? Actually, I got it right here. Never mind.
You got it? Okay. I thought I had to share screen. There you go. You got it. Okay. Yeah, because I'd like people to be able to read it that way. Let's see if it works.
Oh, you know what? I'm able to do it, but I'll have to close out and then rejoin. So we'll have to do this next time.
Okay.
Yeah, I've actually posted this in the Telegram groups, so it's there. But she says this: defendants merely called it, and she's saying it is the alleged virus, what it is commonly known as, COVID-19. There's no reason to believe plaintiff's reference to the virus is anything but COVID-19, and referring to the virus as COVID-19, the term used by the rest of the world and all other courts, cannot be considered a misrepresentation to the court. Well, actually, it can. If you're intending to mislead the court from what is in the actual complaint, that is a misrepresentation to the court. So then she has the gall to say that their motion to dismiss relies on the material facts contained in our complaint. Plaintiffs claim the motion to dismiss relies on hearsay and information not contained in the amended complaint, which is true. Because the only fact that plaintiffs appear to take issue with is whether COVID-19 exists. However, there is no legitimate doubt of COVID's existence. And then she has a footnote here to a previously brief, and I've already debugged that one. I'll talk about that here in a second. She says the court can take judicial notice of it. Well, in order for the court to take judicial notice of it, someone has to file a motion for the court to take judicial notice of it. She hasn't done that. So then here she says all other facts material to the motion to dismiss either came from plaintiff's amended complaint or an attachment. And there's a footnote. I'm glad you guys are sitting down because you're going to laugh your freaking heads off. Bar Attorney of the Year. She wrote this in a court filing. Plaintiffs appear to believe that every pleading, statement of law, or other communication needs to be accompanied by an affidavit. Plaintiffs seem to think that the absence of an affidavit makes the statement hearsay. Mistaken. Brandon, you're going to love this. Nothing in the federal rule. By the way, I don't know what this rule is, okay? This is how she has it written. Federal Rule of Civil Procedure, not federal rules. There's only one, so I would love to know which one she's referring to. Nothing in the Federal Rule of Civil Procedure require defendants to submit an affidavit to every brief. A motion to dismiss that relies on facts from a complaint and contains only legal arguments does not require an affidavit, nor is it hearsay. Hey, Alphonse, remind me of that case from the Pennsylvania District Court, 1964. What the heck was that case called? It was
That little case, Trinsley versus Pagliaro.
oh yeah, that's kind of a big deal case. Why is that, Alphonse? Can you enlighten us?
Well, attorneys cannot file a motion for summary judgment or default judgment because they have no personal knowledge of anything. You need to have a witness to come in and testify to anything the attorney files.
Oh, okay. So how do we get competent witness testimony on the record, Alphonse? How do we do that?
Well, they could start by submitting an affidavit to show that they do have a witness that will come in to testify. But until that witness comes in, that affidavit is hearsay. Anything is hearsay until we get a witness in the stand on there to be cross-examined in a matter. Until that witness gets cross-examined, it's hearsay.
What if I'm Alphonse? What if I'm the affiant and I'm also the named plaintiff? What about my affidavit then? What does it make it before the court?
Well, it makes it fact because
stop.
Well, you could walk into court and testify to it, you know.
Yeah.
So,
and this is
so everyone is clear. That is our golden ticket as pro se litigants, right there.
Yep.
That is distinguished case law that still carries weight today. That was 1964. Oh yeah, hey, see, look at that.
The attorney can't be both. He can't be both the representative of the party and be a witness. He's got to be one or the other. He's got to pick a hand.
The justices that opine that decision said, and I'm quoting, I'm paraphrasing, but I'm quoting exactly. It says statements of counsel are not facts.
I got it. I got it right here. It's up. I just had it up. Here. I'll let you read it. Extend session. There it goes right there. Read it.
So helpful, yeah.
Hold on a second. Look at that. Statements of counsel in their briefs or arguments are not sufficient for purposes of granting a motion to dismiss or for a summary judgment. What are those rules right there?
12B6, 56E.
12B6 and 56E. Okay, so 12B6, that's a motion to dismiss for failure to state a claim, is it not?
Yeah, and E, I have the book out right here. It's failing to properly support or address a fact.
The Bar Attorney of the Year has just told everybody, including a federal district court judge, that the federal rule, not rules, the federal rule of civil procedure does not require affidavits. Just so you're all aware.
Oh, let me ban this this naked hot girl thing over here. Come on, guys, y'all got to do better than that, admins. Okay, so let's go to federal rules of evidence now. We read your rule 56 of the federal rules of civil procedure. Okay, remember, if you take the jurisdictionary course, and you should, if you care about freedom, if you just care, look, even if you're not planning on suing somebody, you don't know what's coming in the future. Okay, what you're going to do is learn the basics. And then with the application of us moving forward and getting live court experience, it's only going to get better. Okay, it only gets better, and you get more confident as you move forward. Okay, so let's double this up, because there's rules of admission, what is called admissible evidence. Okay, authenticating or identifying evidence, Rule 901. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. Examples: the strongest, like James said. So I just wrote a motion in limine to include evidence. Okay, we talked about it, I think, in Alphonse's group. Guys asked why I did that with an affidavit, right? Because it was the easiest way to get it admitted into the court for the trial. Gary recorded the video. Now, we still could have got it in, okay, but I was a witness to it. So Gary couldn't witness to himself recording it, right? It wouldn't be the same, but I could, because there was a firsthand witness and testimony to it, right? So
you had what, Brandon? You had what? Personal
knowledge. So here we go. Testimony of a witness with knowledge. Testimony that an item is what it is claimed to be. Okay, so there's nobody in this continental United States that can testify to ever seeing COVID-19 or anything else of that sort. Okay, there's nobody, and we can move past that goalpost. And the best thing to do is to not to dance around it, just like James has done. My lawsuit's not about a mask; it's about the constitutional the deprivation of constitutional rights at that arbitrary, capricious, and unreasonable means. Look, there's case law. Put signs up. They put signs up 60 years ago. And so it's discriminated arbitrarily and gave the Gestapo's reason to stop people for drinking out of water fountains, whatever it was, whatever the programming is. But you do not. Nobody has that right to just become enforcement of the law with no law to back it. I mean, that's the simplicity of everything that we're doing here. These people are counting on, like this lawyer, everybody knows it's real. Who cares? Woman, you got to bring some admissible evidence into this court supported by facts. And until you do, you're just blowing in the wind with moot subject.
Well, I told you, I replied to her argument, and, sometimes I just think I'm the funniest thing ever. I got her reply to my motion to strike, her motion to dismiss. And, I hinted on the fact, they can't prove that this is real. And I'm not going to say something that's real because I can't prove it. And she came back and said, there's undeniable evidence. The court can take judicial notice because we can take information from relative sources of information that cannot be disputed. So then she proceeded to give some websites. She gave the CDC. She gave the World Health Organization.
The website's always a witness.
At Johns Hopkins University, and then she gave the local health department there. So this is the smart ass that I am. I said, just because I say something is real and I put a website up that says it's real doesn't make it's real. I says that carries about as much weight as me saying that unicorns are real. Because if I do a quick Google search on unicorn, I can find a page on it on Google, on Encyclopedia Britannica, on Wikipedia. I named all these other sites. I said, so by this argument, I'm going to state that unicorns are real. But then at the end of that, I said, obviously unicorns are not real because I cannot prove beyond a shadow of a doubt that they are. Likewise, neither can counsel. So if they're going to stand on that as their defense, the burden of proof is on them. Now, if I had put that in my pleadings, the burden of proof is on me, just like we talked about. So a couple of other quick things, people. You got to realize, too, this motion to dismiss, this is a knee-jerk reaction.
It is.
Well, the attorney wouldn't be doing his job. If they didn't file the motion against you, he wouldn't be doing his job. He's trying to get rid of the suit, okay?
Exactly. So let's make a couple things clear here, too, okay, right? Because my complaint, I had a number of causes of action, but one of them was a declaratory judgment. Hey, Alphonse, real quick question. Does a declaratory judgment state a claim for relief?
No, it just needs it wants the court to make a decision on facts so that if this goes to trial, it's going to tell you pretty much who's going to win. Okay. That's what they're tell you.
So then tell me, how is it proper, if I'm the defendant in that case, is it proper for me to file a 12B6 motion to dismiss, which is a failure to state a claim?
No, because there's no claim to state. You just want the court to rectify the legal issues that if this goes to trial, who's got the law on their side, pretty much, Okay,
so then would that, by definition, constitute a frivolous filing, which then violates rules of civil procedure, federal rules of civil procedure, Rule 11?
Yeah, because I would state that, nowhere have I ever seen that in a declaratory judgment that you state a cause of action, because there's no relief to be given in a declaratory judgment. It's just the court's opinion on, here's my set of facts, here's their set of facts. If this goes to trial, who do you think's going to win this? And then the judge will hand down opinion. Well, listen, plaintiff A says this, and most likely, if this goes to trial, plaintiff A is going to win this case because of this, this, and this. That's what declaratory judgment is.
Exactly. So that's the first thing, people. So like if I can incorporate a declaratory judgment in my pleadings, I do, because it makes it darn near impossible to get that case dismissed for a 12B6.
That's right.
Now, you can dismiss for other stuff. Okay, you can still be dismissed for lack of standing or lack of subject matter jurisdiction. Those are the other things that you can be dismissed on. However, it cannot be dismissed for failure to state a claim. So that's the first thing.
And I'll share this with them to double down on this. This is my motion to strike, right? This is my motion to strike. Where
I was hoping you could bring that back up because it's good.
Yeah. Plaintiffs have, to the best of their ability, incorporated the well-written complaint rule, entering a complaint centered around Article 3 standing of. Okay, there's Article 3 standing requires three things: injury, causation, and redressability. Okay. All right. The constitutional requisites under Article 3 for the existence of standing are that the plaintiffs must have personally suffered some actual or threatened injury, that injury can fairly be traced to the challenge action of the defendant, and that the injury is likely to be redressed by a favorable decision. All right. And I ended up removing all this stuff, by the way. Plaintiffs have alleged the causation for an Article 3 standing court is Chief Cyrus Ben's Ordinance 2020-06-B, which imposed administrative restrictions on living, breathing, and sentient men and women, which exceeded the scope of the chief's authority.
Boom.
Judicial review standards have been fixed since 1803. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that the courts, as well as other departments, that's Marbury versus Madison, by the way. The defendant's counsel, now I've got 500 pages of his motion to dismiss. Not one doggone thing stated anything about the federal question, the constitutional strict scrutiny rule, or the judicial review that I pled in my pleading. None of it, because he knows for a fact that if the court has to rule that the causation of all my injuries was in fact the illegal and unconstitutional mandate by a municipality, because that's exactly what the Indians are. They're a municipality that's protected by the federal government. But that municipal ordinance only applied to the members of that organization. They're more like probably a private membership organization, because you can actually become a member or not become a member. You can leave and come.
Yeah.
But nonetheless, he danced around this issue, and all I did was push it right back at him. Oh, no, you're not getting away from this issue, because this is Article 3 standing. This is not an Article 1 court. That's not what I pled for. And of course, that was the typical litigation tactics, right? And I just go further and further into it. But they are trying to dance around the issues and don't get sidetracked with their musical sideshow, right? And this is what they're doing. They're going like this. Don't look at me. Look over here.
Well,
Tiny ball.
To your point, Brandon, too, you said 500 pages.
Oh yeah, here, look.
Yeah. So
yeah, we talked about that. Listen, when somebody sends you 500 pages, listen, they're trying to BS you.
Yeah. So let me ask you guys this: Are federal district court judges busy? Do they have a lot of cases on their plate?
Yes, they do.
Do they have time to read a 500-page motion?
No, they're not going to read it.
Yep.
You know, if there's one thing that I do love about Dr. Graves, get your pleadings right. If it takes you 30, 40, 50, heck, 150 pages of a pleading to get it right, get it right. But when it comes to filing motions and briefs and things of that nature, less is more. Get to the point. Show them how they're wrong. Show them how the rules and the law state that they're wrong right there. Yep, that's if I were you, Brandon, I would put that I'd put the Trinzi v. Pagliaro reference there just so they're aware.
Well, I did it. I added it in the memorandum.
Oh, you did? Okay.
Yes.
Yeah.
It's added in the memorandum, and so that was added. I just added it in the actual. I want the judge to see it. That's what I want. I want the judge to see exactly what I had in here, and the stuff like this. Defendant's counsel has failed to provide any firsthand witness testimony, i.e., admissible evidence, in contradiction to the plaintiff's complaint, and as such has failed to provide this court with any justification for dismissal or removal of the current action. Plaintiffs have carefully pled with specificity every essential element required for such allegations. Plaintiffs continue to allege that Chief Cyrus Ben's ordinance was the nexus that created a systematic loss of institutional control and a discriminatory environment absent of any legal or lawful authority. Boom. So I'm not going to let them out of it. You're not.
Won't let them out of it. Just don't. I mean, people, the courts have ruled that we have the upper hand. Why do you think these attorneys, these liars, these shysters, why do you think they get so nervous and so scared about going up against a little old pro se? Because they know we're not playing on the same playing field. I mean,
they know if we've gone this far, there's very likely, there is very little doubt that we're willing to go all the way to defend our rights.
I laugh because after I filed, so let me back up in my case a little bit here. So when that shyster filed the motion to dismiss that was full of perjury. So I called her out on it. I did the grown-up thing to do. I sent her an email and I said, hey, I'm noticing some issues here with this. Are you sure you want to go forward with this? She ignored me. Okay, fine. So I went ahead and did two things. Since I'm in federal district court, well, there's, I believe you shared it, Brandon. I know Brett has, but there is a federal criminal complaint that you can file into any district court judge. Well, it just so happens I already have a case. So we filed criminal complaints alleging misrepresentations before the court and perjury before the court, as well as the Utah laws that she violated as well. Then on top of that, I submitted a motion for the court to take judicial notice of that fact under Rule 201. That's how it's properly done, to take judicial notice. And I also did, a little trick that Alphonse does is I had the court take judicial notice of the bar grievance that I filed against her, as well as the other plaintiff.
They hate having that on record, man.
It's so much fun. So then we sent an email out of good faith, say, hey, we're reasonable people. We're willing to talk if you are. And then she sent me this email back and says, well, you just basically did things that are not considered standard, and that's not how we do things, and I don't want to talk to you. Basically, it was like the little kid at the playground that just got her sucker taken away, and she was running off to tell mom. And I was laughing my head off. I mean, this is like, you are supposed to be the cream of the crop of the attorneys in this state, and I'm schooling you, and all of my education has been reading the rules, reading case law, researching case text, researching Google Scholar, researching American jurisprudence. And I'm schooling you in this. You guys, you have to understand, we have the upper hand, because unless there is competent testimony on record, either in the form of an affidavit, in a deposition, or an open court testimony, there are no facts before the court. Period. I don't care what anybody tells you. Love Dr. Graves to death. Don't get me wrong when I say this. I love the man to death, but he is flat out wrong if he thinks that just filing a pleading constitutes facts before the court, because it does not. And we've had to have this conversation.
Well, if you don't object to it, they will take it as facts.
Well, then it's admitted before all the court, right?
Exactly.
And so you have to understand their perspective in that thought process, right? Because
they're
lawyers
used to get away with that. They get away with that so many times.
Yeah, lawyers aren't going to go play that ball game because neither one of them have firsthand witness testimony.
You're lying too.
Yeah, and it's like the lawyer I recused for my dad's case. We don't usually do this. I know, but you lied. You had a conflict of interest, and now you're a material witness, and you knew this. That means you were committing fraud. You're dishonest. I can't have you in this courtroom.
I got to share this with you. I mean, you guys will love this real quick. This is how you take a little thing, okay, a little minuscule thing, and you literally blow it up into a federal racketeering case. And it's amazing how this happens. Through a standard little record request. I got a buddy, Carmen, okay? He's got a nice 2017 Corvette. So Carmen's got this old beat-up pickup truck, and he parks his nice Corvette on the lawn next to the truck so he don't have to shuffle cars. He's now gotten 3 citations for parking on his own lawn, okay? So this led to a record request. So we do the first record request. Guess what? The borough never even responds. That forces me to do an appeal to the appeals officer. Appeals officer contacts him and says, hey, you got to respond to this. So they respond. You're going to love this. The attorney that responds, now, like Brandon said, he filed a participation. He's got to file a record of participation in the matter. I used to fight that. I don't fight that anymore. I want the minute. I want the right stuff, okay? So I don't fight that anymore. Because here's what he did. I asked for 2 records. I asked for all the citations issued against him, against Carmen, and I asked for evidence that this parking on a non-paved area has anything to do with Carmen. Okay, the record for that. The attorney, I kid you not, he files a sworn statement saying there's either a criminal or non-criminal investigation going on. He can't turn over those records. So twice the appeals officer contacts him and says, you haven't given me anything to prove there's an investigation going on. So finally, they just drop it, the borough. In other words, there is no investigation going on. Now we got the attorney in a simple record request. He's now perjured himself. We now got proof of it. We got the appeals officer saying, contacted him twice. He ain't got no records, okay? Then, here's the, you're going to love this, the cherry on top. The code officer that started this, well, we wanted to find out his salary information, his bonuses. We want to find out how he's making his money. We asked for all his employment records. I kid you not. I can't make this up. The town manager, the borough manager, states, we don't have any records on this guy. He actually said we don't have records on this guy, which then led here, let me read it to you. This is classic. Now, this is coming from, like Brandon, you're saying, play it straight, because sooner or later, an adult's going to get involved in this, and he's going to get pissed off, okay? And he's going to know his chain's being jerked by some attorney. So here's what the attorney wrote in response to them not having any records on their code enforcer. They hired him, but they got no records for him. So he states, he said, items 8 to 10 seek information regarding Rich Slifer's code enforcement officer of the borough. We said, this information includes any contracts, agreements, employment agreements, compensation, income, including salary, bonuses, and incentives, job description, and duties as a code enforcement officer. He said, although the borough presented evidence that these type of records do not exist, he said, it defies logic that such information does not exist and that the borough would not maintain this type of information from a borough employee. He said, surely a borough code enforcement officer would have some sort of contractual agreement that includes compensation, salary, and a job description. He said, as such, without further explanation, the OOR, which is the appeal office, finds it incredulous that these type of records do not exist and will order disclosure of items 8 to 10 of the request. Therefore, the borough has not met its burden of proof that it does not possess these records. Man. So he's basically saying, hey, listen, even if you guys submit an affidavit stating you don't have the records, it defies logic. It's incredulous that you don't have records for an employee. So now here's what we got. Would that be a violation of the employment laws, guys?
Yeah.
They have to have records for this guy, the code enforcer. So now they're saying they got a code guy. They got a code guy running around filing legal actions against people, and they got no records on him. They got no salary information on them. They got no agreements with them. Are you kidding me? So now I do a second record request, and it's more involved with taxes. So the second,
I'll be right back, guys.
Sure. Okay. After the first one we filed criminal complaints against everybody. Of course, the DA, they shelved them. There's no probable cause. But here's what happened. We did the second request. They didn't answer that, okay? The borough never responded. The appeals officer, we do an appeal. We do an appeal. The appeals officer tries to contact them. They ignore the appeals officer. They don't even want to deal with the appeal officer now. The appeal officer put this statement out today saying, they have failed to participate. Listen, they've now got to turn over all these records that they don't have. So now we're moving towards federal racketeering. Now I have the DA. I filed the state criminal complaints with the DA. Would they say there's no probable cause? Thank you, Mr. District Attorney. Now I'm going to take you. I'm going to name you as a defendant, and I'm going to take the borough, and we're going to move them all to the special agent in charge of the FBI. Because guess what I have on my side now, Brandon? I got statements from appeals officers of Pennsylvania saying what they're doing is incredulous. It defies logic, okay? So now we get to an attorney that does this stuff saying this is incredulous. How can you not have records on an employee? Yet the DA, that's no big deal. We got an attorney perjuring himself, and we got a code enforcement officer with no records at the borough. That's no big deal for the DA. So now I'm going to move Mr. DA to the special agent in charge, and we're going to file federal criminal complaints against him. and we're starting to widen, like Randy, we're starting to widen this out now. Now they're starting to get nervous. Now, when we sue these idiots, Carmen's going to walk away with a 50 or 100 grand easy. We're not going to trial.
Well, and it's like I told,
myself, and I got no records for the code enforcement.
It's like I told, I can't remember who I was in a conversation with the other day. So you start off, and the little ripple that you initially make by standing and quitting, stop being silent, okay, and bowing the knee to these insane people. You got to stop today. Quit bowing the knee, and quit making excuses for yourself of why you can't do something. Yes, you can. If you can't psychologically grasp that this isn't really that tough, you're just going to have to spend some time reading and writing, okay? And as you write more and you read more, you're going to get stronger and stronger, okay? But what happens, it's like the sergeant that I met the other day. This guy, when he come up here, he was scared to death of me. And I asked him, I told you.
What were you, Brandon, categorized? What they categorize you as?
I asked him, I said, why are you so nervous? Well, they've got you labeled as a sovereign citizen. And I said, well, I assure you, I am sovereign. And I explained to him how I am, and that it's a singular principle, right? And that sovereignty dictates that I understand my duty to those around me, and I don't breach that duty at any point in time. And he looks at me and he goes, man, I don't know if I've ever heard it like that. I said, that's what sovereign means. Okay.
Did you tell him he's sovereign as well?
Yeah. And so he tells me everything on the record, right? And he's sharing with me all the information. He says, oh, yeah, it was Dwayne Crawford. He's showing me the report on his phone.
Threw him under the bus.
Yeah, on his phone. And I go, okay, now we're going to go off the record. You haven't read me my Miranda rights, so we're not in a criminal investigation, are we? He goes, no, there's no criminal investigation. He goes, there's no criminal investigation here. We're just, the director told me to come here. That's what he told me. And I go, okay, let's go off the record. Let's have a conversation, mano a mano. And I said, hypothetically, I said, since the alligator is a nuisance animal here in the state of Louisiana, he goes, oh, yeah, it's a nuisance animal. I said, I had 4 kids down there. That's in that report, ain't it? He said, oh, yeah, Dwayne told us about the 4 children that I had there. I said, so just hear me out here. Hypothetically thinking, if an alligator got within 3 foot of any of my children, what could I have done? Oh, you can kill it. I said, I'm just making sure that y'all understand what I can do moving forward here. I can say anything because y'all don't know nothing. And we started to have a great conversation. Let me get back to the point of the ripple and the psychological effects of people starting to see people stand up. Okay, there's good people out there in positions of power waiting for you waiting for me. And once they see, because they have follow mentalities, they're sitting back, they're scared, they don't know what to do. And then what's going to happen when we start breaking this thing open? More people are going to follow in that path and say, no, we don't want to go the way of cultural Marxism, right? This is not what we want to do, where we psychologically enslave ourselves, where up is down, left is right, men are women, women are men, children, whatever we want to say in this land of clown world. And they're going to attach to it. And that conversation ended. He gives me his card, and where's my phone at? It was such a great conversation. I sent him a text message after I got all the information I needed out of him. And I sent him a deal, and I just want to read it to people because you can be nice. I said, Sergeant Randy, this is Brandon Sibley. And today I contacted the Director of Wildlife Fisheries again. And in the letter, I commented and commended your professionalism regarding the interaction between you and I. I pray that it assists you in some way, shape, or form. I cannot count on that ever reaching you, so I wanted to make sure you receive the compliment right from the horse's mouth. Thank you so much for engaging in mentally stimulating conversation, and let's both pray that we don't lose this great republic to incompetent, ignorant, and flagrant abuse and disregard for the rule of law. Okay, what did I just do with that guy? I created a picture in his mindset, right? So now he's got to deal with the fact that he's being trained that sovereign citizens are some type of bad guys, right? Mm-hmm. Okay. I'm not a bad guy. I'm not looking to harm anybody. Matter of fact, I just want to be left the hell alone. Mm-hmm. And it's going to happen. It will happen. By the time I'm done with these people around here, they're going to know, hey, y'all just leave that guy alone.
Yeah, don't bother him. He's going to shoot you.
So it's kind of like, so one of the things I do for my day job, right? We all have to have those, unfortunately, until we win our lawsuits. My day job is I sell software to law enforcement, and they can put zones around properties, and they can label that zone however they want. So I guarantee you that within a 3-mile radius of Steve's home in Orlando, there's something that says, do not go near this guy's house.
They said 3 blocks. The code guy don't come within 3 blocks of the house.
Yep. I guarantee there is something there.
Well, here's funny, Brandon, what you were talking about. Listen, when I first started doing record requests, here's what I tell people. Listen, start out by doing a record request. Like Brandon said, most people are not good writers, okay? And I wasn't a good writer. Listen, I was a good writer, but I didn't know how to play the legal game with the record requests. And then I would file record requests, and I'd find out how they would knock them down, and then I would get more creative, and I would start moving my stuff, okay, around a little bit. So all the appeals officers they know me up in Pennsylvania. After you do the record request, you then appeal it. Dude, I know all the names, and they know me. Now, here's what's happened in the last few record requests. It's no longer adversarial where they side with the municipality. Guess who they sort of been siding with now? They've been siding with me, okay? Because I'm talking about the law. Hey, listen, give me this record. How did I become a taxpayer? What record do you have that provide this to me? Now it started to shift. So what that tells me is I'm not just the only one doing this now. A lot of people have taken my paperwork, and they're starting to file record requests in Pennsylvania. So now they're starting to see a shift happen in Pennsylvania as far as, hey, the monkeys are wising, they're becoming enlightened, okay? They're now asking questions. Hey, how exactly did I become a taxpayer when I bought a house or I got a job? Because I can't find it anywhere in any law where it states when you buy a house, you get a job, you become a taxpayer. It doesn't exist, but they don't want to tell you that. So start out with doing record requests. Start honing your skills. You'll learn how to communicate with these people back and forth, and you'll start to get better at writing stuff. Because I think that's the biggest fear most people have is they're not used to doing this, and they're afraid that these people are going to do something to them. Here's how it works. When you run at somebody, they run away from you, okay? They don't run at you. So when you start running at these people, they're going to back off from you. They're not going to come harder at you. They're going to back off. And you just got to sort of get rid of that fear and just take that first step and start doing some record requests.
And you do. And I just want to hit on the taxpayer deal because we've had a lot of questions here in both groups recently about the IRS. Okay. I just want to touch on this, guys. Listen to me. I do not advise. One guy private messaged me the other day. He says, Brandon, I don't know what to do with my W-2 form and how to go exempt. And I said, well, unfortunately, it's right on the instructions. Okay. I said, you're not ready to go down that path. Okay. It's very easy to defeat the IRS, probably the easiest thing I've ever done. But at the same time, don't do it until you actually understand statutory construction, folks. If you have not watched the last episode, Alphonse and I, that we did, where we went through administrative law, we went through how the Supreme Court, not some monkey kangaroo court, how the Supreme Court reads statutory construction by context, and that there's what we tell you and what we've been trying to explain to people is that the overarching reach of the administrative agencies have abrogated the rule of law in this country is exactly why your Supreme Court ruled against the EPA and the broadening of their statutes, which was a big hit on the Chevron difference, bro. I haven't heard anybody bring this up yet, that this was a direct attack by the Supreme Court on the Chevron deference. And that's where administrative agencies get to interpret their own statutes, okay? And broaden them like the CDC did. Right. So that's being attacked right now. It's a perfect time to understand this, but don't go in reading chapter title 267701, right? Or title whatever. I can't even remember the definition.
3401.
Yeah, and you go in there and you read a person is defined as an individual, corporation, joint stock company, business association, organization, whatever, and you don't understand by statutory context that all the definitions of each and everything after individual includes uh, uh, the creations of the state, which are domiciled in the state and have to be domiciled in the state of its creator. And there is where that creation must lie. So it creates a subjection to, so the individual has to be a sole proprietorship. If you don't understand that, don't even bring up anything else. You have to learn the basics. There's no point in making it overcomplicated. Don't go out there and decide that you're not going to pay your taxes and then come running up. I need help right now. Right? Look, take your time, go through the videos. We're putting a small series together. Thank God, thank goodness for James coming and Alphonse coming once every few weeks when I get time. I wish I could do them every week, guys. I just can't. I'm so busy with so much other stuff. I can't put. I work too. I come home and work, tap away on the computer till 8, 9 o'clock at night, and then you just run out of time. Okay.
Hey, Brandon, let me read this real quick. I pulled this right off the IRSGov website. You can go pull it off yourself. Now, get this. The general rule is that an individual is an independent contractor. Hello? Now, all those other terms after individual, aren't they all corporations? Yeah. So he's an independent contractor. He's not a corporation. It's right there on IRS website. I didn't make it up.
You know, to that point, there was a video floating around from a former IRS auditor. I want to say her name is Sherry Jackson, maybe. I could be wrong on that. But she recently took the IRS to court, or she was being prosecuted for tax evasion and tax fraud, and she lost her case because she put her entire this. Okay, now this is a woman who worked for the IRS, right? Don't you think she would know everything, all the ins and the outs? Her argument was that she was not an individual. That was her entire argument. The jury didn't buy it. They convicted her. So she spent, I think, 6 months in prison, I want to say.
Well, and she went through tax court, right?
Exactly.
Tax
administrative judicial court.
That's an executive functioning. That's Article 1, okay? And that's the number one thing. That's why you must exhaust. And look, they're going to go after this too. I know it is. Because at this point in time, when you're dealing with the IRS, you must exhaust administrative remedy with them, okay? You have to. That means every time they send you a letter, you send one back. They've made a claim, right? They ask you, do you consent or do you not consent to this tax? And you go, no, I do not. I do not consent. I've got some questions right here. How am I a federal franchise scheme or taxpayer as defined by your code, which the statutory construct and designation of individual as outlined in your code states that I'm not. I can't be, okay? And you just keep sending them back, and then eventually they go. I've shown y'all the three pieces of paper. We need more time to research our code. That's been 2 years ago now. Okay, 2 years ago, I haven't heard from them again, and I have not paid a dime in income tax. But you must understand what you're doing. And hell, even then, 2 years ago, they'd be in a hell of a lot more trouble today against me right now than they were 2 years ago. Because I just wanted them to leave me alone then. Now it would be a totally different story. You send me another. If they would just send me something right now, I'd just go straight to an Article 3 court.
Yep.
And here's what people get confused when we're talking about statutory construction. Here's really the basics of statutory construction. If the Congress enumerates specific things, it excludes all other things. So if they're talking about fruit, and we all know a pineapple's a fruit, but they're talking about oranges and apples and bananas, and pineapples are not in that list, guess what? Pineapples are not applicable to that whatever thing is, okay? They've the courts have stated, listen, there's a reason the Congress specifically named these things because they wanted to exclude the other things, okay? That's what statutory construction is, okay? It, like Brand's saying, it means in context and it means in enumeration. So if we're talking about this, and this specific thing, it can't be something outside the list. Okay. And it's got to be taken in context to how that statute's written. Is it written for me or is it written for some corporation?
See, Alphonse, though, here's the problem. 95% of the people that you interact with on a daily basis, when I say you, I mean everybody watching this, They don't know that.
No.
They will read the law and they'll say a person this, a person that, and go, oh, well, that must be me. I'm a person. Brandon, I consider Brandon a person. I consider Alphonse a person. But see, here's the thing. In everyday speak, it's completely different from the legal term definition of the term. Not even close to being the same.
Funny, Steve said, Pennsylvania's got one of the greatest definitions of taxpayer he's seen in any state. It's Title 61, 153.1 and 155.1. Now, you tell me if this is you guys. It states taxpayer, and the other one's taxpayers. 153.1's taxpayer, 155.1's taxpayers. Organized an entity, organized and incorporated in the Commonwealth of Pennsylvania and doing business in the Commonwealth of Pennsylvania. Is that me or you? Are we organized and incorporated? No. Are we an entity organized and incorporated in the Commonwealth? Are we doing business in the Commonwealth? Then we don't meet the statutory, like we're saying, statutory definition. It states right there what a taxpayer is. You can't reach outside of it and go, well, Brandon has a job. I think he's a legal entity. Let's consider him a legal. No. Organized and incorporated in the Commonwealth and doing business in the Commonwealth. You're not organized and incorporated in your state. You're not organized and incorporated in your state unless you have a business, unless you willingly went down there and registered a business. That's what statutory construction is. They can't sort of go outside the statute and just sort of make things up so it sort of fits their need. Can't do it. Got to be written down.
Yeah. I mean, again, the burden of proof is always on the moving party, is it not? So if they are trying to come into my house and tell me I'm a taxpayer, great. Show me the evidence. Oh, and by the way, prima facie evidence doesn't count here for anything that I see. I get to claim ignorance of the law because I'm not an officer of the court.
Guess what prima facie evidence dies, James?
Exactly.
When you challenge it. It's actually written down like that. It will stand until you turn around and say, I deny that. So now the burden of proof shifts back to them, and they now got to prove their evidence.
Yep.
Here's the other big scam they're doing, everybody. It's got people confused with driving citations. Listen, they have created what's called summary offense process. Every state has it, okay? Summary offense means basically, really, it's a bill of attainder. In other words, you have an officer or a code guy, he's going to write you a fine, okay? And they're just going to fine you without any due process, without any trial by jury. So to look at it logically, your right to trial by jury is inviolate. It's permanent, can never be toyed with, can never be taken away with. And you always have a right to due process of law. Due process means a notice and an opportunity to defend yourself before anyone does anything to you.
Yep.
Now, you can't have these inviolate, inherent, permanent rights, and then them turn around and go, listen, you got them rights, except when the municipality turns around and they write you a citation. Then we suspend the Constitution, we suspend due process, and we suspend that trial by jury. You can't have the two things exist at the same. So this can never exist with this. So that tells you that process was never written for you or me. Because you and I have a right to trial by jury all the time. So how are you going to put me in this summary offense process, which is every driving citation you got, every code enforcement citation you get? How are you sticking me in this citation process that right off the bat violates due process, trial by jury, and it's a bill of attainder? You're fining me without any court case.
The same is true, Alphonse, not only for municipalities, but also for county organizations and state organizations. So the county sheriff, the state police, highway patrol, anybody that hands you a citation and expects you to show up in court and defend that falls under that. And I'm glad you're pulling this up.
Well, Jake, isn't it funny that they, when they say, well, in Pennsylvania, they don't ask you to sign anything, but I know some states ask you to sign. Guess what you're signing when you sign that little citation? Guess what you're agreeing to when you sign that citation?
To be into an administrative court?
You're agreeing to show up.
Appear.
You're agreeing to appear, okay? So wait a minute. If you need me to sign that, what if I don't want to sign it? Then I guess I don't have to appear there, do I? I never made any promise to appear. So then how could they issue a bench warrant for you if you never agreed to appear in that matter? And that court has no complaint before it, no civil or criminal complaint before it. and it never gave you a notice and opportunity to defend yourself.
Yeah.
They can't.
I do want to give somebody everybody a caveat too, by the way. Because James brought up the respondent superior deal. If you're going to cite Civil Rights Act of 1871, just know that a municipality cannot be held liable for violation of civil rights solely because employee is a tortfeasor. It has to be by training. Okay.
Yeah, that's what you mentioned. That. Yeah.
A municipality cannot be held liable on a respondent superior, but local governments, that includes counties, parishes, and things of that sort, cities and everything else, may be sued for constitutional deprivations visited pursuant to governmental custom, even though such custom has not received formal approval through the body's official decision-making channels. And that goes back to rulemaking authorities and all that other stuff, where they're supposed to involve you, the members of that organization, into the rulemaking process, and it's completely administrative. Okay, it has nothing to do with the protection of your fundamental, foundational rights as a living man and woman.
Mm-hmm. So true.
Yeah,
well, hey, we're coming up on an hour and 45 minutes, and it's felt like we've only talked for about 10.
He hasn't been that long already. I didn't even realize.
I can tell you right now, if Anna Von Reitz is on here, we all would have actually spoken for maybe 10 seconds, and she would have taken up the rest of the time. So you guys don't understand what a privilege that is. You have got to do it. No, you don't. No, you don't. Trust me, you don't.
Here's the basics of an education. They taught you about separation of powers as a kid in school, right? But you never really related it to anything. Let me ask you this: the municipality that's doing all this stuff, which branch do they fall under? The executive, right?
Executive branch, because they hold all functions.
About you? Can they make any kind of legal determination about you whatsoever?
Nope.
So if they can't make legal determinations about you, because they'll say, well, this law applies to you. Well, then show me the record. That's your record request. Provide the record that shows that there's a taxable situs at this property.
Mm-hmm.
Because you can't make a legal determination about me. The only way you can have a taxable situs, James and Brandon, is if I registered a business with the state.
Yep.
I filed returns with the state. Then they'd say, hey, Mr. Fagiolo, you registered the business. Here's your return. We have a taxable situs with you.
Yeah.
So if that doesn't exist, how does the municipality claim that you're a taxpayer? Is there anybody from the state coming in to testify against you? Anyone from the Commonwealth of Pennsylvania coming in to testify against me that I'm a taxpayer?
No, they're going to use circular logic, just like these quasi-judicial judges, and go, we say it so because it is so.
Right. Hey, by the way, guys, the court can take judicial notice of COVID-19, just so you're aware.
It is because it is.
It's because I said so.
Yeah. No,
I feel like I'm 5 years old listening to my mom again because I said so.
Well, and we go back to this, right? And so, people want to trash this system, and I know that's the misinformation, and I was one of those too, right? It's the system. It's the system. It's the system. No, it's not. It's the people. Yeah, it is the people. Systems don't commit crimes against others. You don't have to look any further than your neighbor, your brother, your sister, whatever. Man commits crime. As far as systems of men, and I've studied plenty of them, a plethora of them in my deep dives and everything else. As far as giving each man the opportunity to present his case, this system, the adversarial system, is the best system on earth.
Period.
It gives you the opportunity to go inside this court and use what we'll call Article 3 standing, right, and demand it. And invoke your liberties, right? Invoke them. And a man's silent is in acquiescence, right? And of course, we saw that in the court cases I showed earlier with the tacit consent. All this stuff has to be torn down. Yes, it has overreached its boundaries, and it's made an animal farm and made everybody this taxable to provide. Oh, we got to have public education, right? You got to have maintained and operated.
Who's gonna pay for the roads? Who's gonna pay for the roads?
Well, that's taxed already. That's already done in your gas tax and everything else, right? So that's taken care of. No, what they are fleecing you, and these school systems are just profiting out the roof.
They're the worst part. They're the worst part of your tax bill is the school system.
It is. I can't remember who that was. It may be the lady. We asked for it's one of them that I'm helping. We got a records request back in, and it stated at the top. It listed out the why the totals were there, and it stated schools, medical facilities, and then operated and maintained M&O maintained and operation of the county. Okay, so you're paying for the bastards of the medical industry and the school system to dumb you down and then poke you up and kill you.
You're funding your own destruction, like Steve would say. You're funding your own destruction is what you're doing. Yeah.
You know, one thing I want to touch on real quick before we wrap this up, guys, is I've heard this time and again. People are like, the courts are corrupt. The courts are corrupt. The courts are corrupt. I'm just going to tell you right now, that has not been my experience. Now, by the way, I have chosen, because of the issues I'm working with, they're all state issues. So I have chosen to go to the federal court, and that is not what I'm seeing in the federal court. State courts, I'll debate with you on that one all day long because, that from what I'm seeing where I live, they are pretty much
railroad you. They're going to railroad.
Well, we here have a very bad federal judge. Her name is Shelley D. Dick. Okay?
Yep.
We have a very bad one.
You're going to find them. So what's interesting here in my situation is my cases have been assigned to a federal district judge who was appointed by Bill Clinton. So that doesn't look very good for me. However, a lot of these federal courts have magistrate judges, and Randy has talked about this on his show on the Rule of Law Radio. What a magistrate judge is, they're basically trying to become a district court judge. But what I'm finding is this magistrate judge has been reviewing my stuff. She's got a freaking head on her shoulders. She's very sharp. She's intelligent. Her briefings are to the point, and she sticks to the law. So what I'm trying to get at is there are adults, like we say, that somewhere along the line is going to get a hold of this. And I'll give you a quick example. The 11th Circuit Court of Appeals issued an opinion regarding a situation where an individual was tried administratively and was fined administratively, and he appealed that to the 11th Circuit Court of Appeals. They overturned it and said that, guess what? They violated his 7th Amendment right to a trial by jury in a suit at common law. Hold on a second. I've never heard that one before. How many of you guys have all heard that we don't have common law courts anymore? Bullshit. And that's the only time.
Common law, when they talk common law, they're talking, people get confused. They think they're going to start this. It's a whole separate court. No, listen, common law is a set of principles. You have a right to trial by jury. You have a right to due process, and you have a right to question your accuser. Okay. If they're not doing that, you're not in a common law court. You're in some statutory court where they say, hey, we could bypass trial by jury, due process. Oh, and the rules of evidence, we'll just make it up as we go along, you know. Mm-hmm. Hey, we're going to let the clerk do judgments. Okay? The clerk can issue judgments in this matter. That's statutory. That's all statutory crap, basically. It's administrative law. Has nothing to do with a judicial court. Okay, so they can do anything they want in that little kangaroo court. They could make any rules up they want. So your duty is to get the hell out of there, okay? And you do it through filing against them and calling them on stuff.
Well, and while you're there, you're putting actual judicial motions in, and you are stockpiling admissible evidence to go to a court of competent jurisdiction because they're going to continue doing it. They're going to continue. Yeah. You're going to continue putting in your judicial notice of adjudicated facts. Well, that don't apply here. Well, that's fine. That's fine.
No, I think at 15 motions. The Stewart Authority case, I think I had 15 motions denied.
Yeah.
I don't know.
Not a witness on the other side. No witness on the other side. But they denied all 15 motions.
Yeah.
Many without trial, without hearings, okay?
Well, it's like I said, these state courts, most of them, again, they're all in the good old boy system. It's all controlled by the bar, by whatever state you're in. By like where I live in Utah, the Utah State Bar, or the California Bar, the Nevada, Louisiana, or Pennsylvania, whatever. They all know each other. They all understand, but they don't see the big picture. I was telling Brandon, I've got an individual who reached out to me on Telegram who it's a very similar situation where the State Department of Fish and Wildlife decided to fly a drone over her property, take some pictures, and then upon further review of those pictures, it looks like she might be growing some questionable substance. And so they took that and then went and got a quote unquote search warrant, which didn't have the attached the affidavit of probable cause, the whole 9 yards. So I worked with her and I wrote up this motion to get her property back pursuant to the rule. Like there's the federal rule, it's Rule 41 in the federal rules, but in this case, she's in a state court. So I found it's actually under the California Penal Code. We wrote this up, and she's got this stupid attorney that she paid money for before she came to work with us. And this attorney, this is why I'm saying these liars are stupid.
They are.
She sent to me what he said, and I'll just share real quick with you guys. It's short. He says this: by replying primarily on out-of-date federal cases, that including a 2006 District of New Mexico case that has little weight in a California court, let alone a federal district court. He says, in his opinion, that this motion is flawed. So there's that one. By interpreting California state statutes in ways that are not helpful to suppression. We made the argument that the California Department of Fish and Wildlife does not have jurisdiction to obtain a search warrant over her because by the statute, they don't.
Right.
And this dipshit, it's getting late. I'm starting to cuss.
Go ahead, finish it up.
This dipshit had the gall to tell her that that's not helpful to your suppression. And then he also says by arguing that federal cases interpreting federal law dictate how California warrants should be prepared and served. Hold on a freaking second, you idiot. Which constitutional right is guaranteed and secured? Which one of those is that a federal or is that a state law? I mean, I'm confused here. Because from my understanding, those are put into place to guarantee and protect my rights. I give a rat's ass about what California does.
Yeah, supremacy clause, federal constitution, supreme law of the land. Anything in conflict is notwithstanding.
Well, and you invoke the full faith and credit clause too, so he can say whatever he wants to say. But in my memorandum, and I just put that up there for you, by the way. The California Fish and Game is just a simple commission. It's executive branch only.
That's all it is.
Same thing as Louisiana, right? But again, I invoked Senator Tony Spell's Supreme Court case in Louisiana in my motion, right? I invoked it, the full faith and credit clause. I'm a resident of Louisiana. Don't try to tell me that doesn't apply to me. That John Bell Edwards' edict proclamation was unconstitutional. He has the power of the state, and yet a private membership association or whatever the Indians are, I still can't figure it out. An organization.
Ain't that funny? Can't get a straight answer.
Yeah, I can't figure it out. But that chief operating as an executive function, controlling all three avenues of the government, right, with his ordinance, which is the lowest form of law possible. If his edict isn't unconstitutional, is constitutional, and John Bell Edwards isn't, we got a problem here. Okay. And so that full faith and credit clause of the United States is learning how to maneuver through this stuff and simply read things and understand. Yes, your reading comprehension is not as high as it's supposed to be. Neither was mine until I started reading this stuff, right? And then you grasp that you got to slow down. You're not speed reading a Stephen King novel here, okay? Mm-hmm. Precise language is important, and you'll get better at it the more you train your mind to see it.
Hey, Brandon, real quick, I'm not sure if you can put that last question up on the screen there from Joel, I'm not sure if he really got a chance to finish the
Yeah, if you
entire
got any,
question.
if they got questions, Brady, if they wanted to ask
Yeah,
questions,
I'm sorry.
Yeah,
If y'all got, hey, let me do this. Let's do the last 10 minutes here. Let's give 10 minutes. If people have questions, let's get some questions in here.
Yeah, we've only waited till 2 hours in to get your questions. But hey,
Well,
next time we promise we'll cut it down to an hour and 45 minutes before we get to your questions. So something to look forward to.
Question session.
So I'm not sure what Joel's entire question is here. I'm wondering, oh, there it is right there. So if the state courts are mostly corrupt, acting as quasi-judicial courts, should we go straight to federal court? So here's what I would do, and here's what I have advised people to do. You've got these, I'll call them criminals because that's what they are. You got these criminals moving this action in a quasi court against you. They're not going to stop. They're going to keep doing what they've been doing because they think they're supposed to, or because they know what they're doing is wrong and they don't care anyway. But something everybody needs to understand is it doesn't matter what court it is, whether it's an administrative court or a court of record. The question of subject matter jurisdiction can always be challenged, and it can never be waived, ever. So when you raise that objection in writing, like Alphonse and Brandon and I tell people to do, now it's just like Randy says, that's a threshold issue. We know why it's called a threshold, right? That's the part
the beginning.
It's on the bottom. You can't go through the door unless you step over the threshold. So once that's there and on the record, if they just move past that like it didn't exist, whoop, that court is now invalid.
It's an appealable issue, right?
Well,
right.
It's an appealable issue if you want to stay playing in that court. So I don't mess around with that stuff, and I know Alphonse doesn't either. Neither does Steve.
Okay,
well, no,
I haven't
the
had any
coolest way to think about it
movement.
is if it's a state acts, if the state's doing something or so, if I can have a nexus with the state, I know it's a state actor doing it, I'm going to the feds.
Yeah.
If it's a like a local business, I can't bring them in the feds until they turn around and tell me, well, they're following a governor's edict. Well, now I have a state nexus. Now I bring them into the feds. Okay.
Yeah.
So you always want to bring the locals into the feds, and you always want to bring the feds to the locals. So if I have a state issue, I'm going to sue them in federal court. If I have a federal issue, I'm bringing them into state court.
Exactly.
Yeah, so, and only thing I wanted to do that with the injunctive relief against Shelley D. Dick, which we still have to file that. It's 97. That complaint is 97% complete done. But because it's been 3 or 4 weeks, I got to go check and make sure that they're still blocking access in the court for vaccine passports. But nonetheless, the Bevins claim, right? Yeah, federal employees go on a Bevins claim. Blevins, whichever one.
One of those two. Close enough.
Yeah. So make sure you follow which claims are correct. Now, my personal opinion is I'm gonna try something in Baton Rouge District Court here. And the reason for that is the seat of all political power in Louisiana, and I want to try it out with the intention, if it doesn't work, going back to the federal, because I'm seeing a pattern in federal, and that's just to say, oh, by the way, you guys need to know I'm here. Okay, now let me answer Marcus Aurelius's question. No, the only way that I know that your employer cannot possibly be a third party instructor against you is by cash. Everything else, 1099, everything else, they're gonna report on you. So there's no way around that.
So there is actually a form. It's a W-8BEN, but I wouldn't recommend doing it because you're gonna fill it out, send it to your employer, and they can come back and go, "What the hell is this?"
No, they're not gonna do that. I love the W-8BN, and the instructions on it are good. I have yet to see one employer accept it.
Yeah, they won't accept it. I submitted one to my employer, and I got a sharply worded email from our legal counsel. Now, if I had the time to take that ass hat on, I totally would, but but I don't. I'm too busy helping other things. So I was like, all right, I'll just I will do this differently. They're going to send my money to the IRS. I'll do it a different way. So
yeah, and so what happened with me? I did the exemption, and I'm just going to tell people what my process went. I filed exempt, I think it's under line 4. You write exempt. That's the instructions. Okay. I sent that in, right? And the CPA trying to make conclusions of law on me that she was gonna decide my tax liability. Well, I wrote a strongly worded letter saying, hey, if you're gonna do that, we got problems. You're not following the actual instructions on the damn sheet. You can't tell me I'm.
Why don't you fill it out for me? Here, I'll give it to you. You fill it out.
And my owner, he comes back. He said, "Man, you can't do." I said, "The hell I can't." I'm sorry, Greg. I brought the letters up there from the IRS and said, "Greg, I beat these bastards. I'm not paying them. Okay, just not going to do it." About I guess it was a month. I got paid a couple checks on the exempt status, and then he come back. He said, "Hey, we're going to 1099 you." I don't care what you do. All right. So I think I have the same situation as Big Sip's daughter. Y'all move that guy. What is the deal with this naked dude? I think I have the same situation as Big Sip's daughter. I need to sue for unlawful termination. Any advice? Should I ask on Telegram? Well, you can ask here also. Okay. Depending on your state. What I did for my daughter, and now when we go to this mediation next week, the only thing we're settling for is the max amount. Now, this is an EEOC complaint. Okay. Now, because my written complaint, I didn't fill out any of their forms. I faxed and mailed a written complaint stating all the causes of action that included a hell of a lot more than just discrimination, which they can deal with. Right. I have been in the process of training my daughter to the point that where when we go to this mediation next Wednesday, if they don't settle for what we want, that we're going to go to the next level. Now that's going to be her choice. Okay. She's 25 years old. If they offer her $150,000 next Wednesday or something, anything over probably $50,000, $60,000, guess what my daughter's probably going to do?
Take it.
She's probably going to take it. And that's fine. That's fine. I'm okay with that. But you have to, I hope you made a great timeline of events, and every time they sent you an email, when you have issues like this, you need to fire back. You need to fire back and rebut it. You've got to so I have all emails. I've got 10 people involved with the religious persecution, legal coercion, and intentional infliction of emotional stress on my daughter without any legal or lawful authority, trying to force her to take an emergency use authorization drug. They're in a bind. Okay. They're in a bind. They're in a very big bind. You should get in the groups. I put all kind of stuff in there on this particular avenue a few months back. I've kind of gotten off of it because I've gone other ways. But I posted a bunch of stuff regarding this, okay, to help people in your situation. Anybody else?
Real quick, let me just add to that too, Brandon. You all need to understand that if there is a federal or a state law on the books that doesn't carry criminal penalties, you, as a citizen of your state, have the authority and the right to quote unquote prosecute that individually civilly, if that makes sense. So I'll give you a good example. What is it? Is it Title 20 or Title 32, 360 triple B? Remind me, Brandon, the EUA.
Oh, it's Title 7 of the Civil Rights Act of 1964. Is that what you're talking about? Oh, sorry.
No, I'm talking about the 360 triple B, which is the
oh yeah, I know.
The Emergency Use Authorization Act. Basically,
right. Yeah. Right. Which means it has to be fully voluntary. Okay.
Exactly. There's two things that law says. A, you have to be given full informed consent, and B, you have to have the right to refuse the treatment. That is a right that is guaranteed to you by statute. So if you have individuals who are denying you that right, well, now they just committed a felony under 241 and 242 if more people are involved, right? So you as a private citizen don't have the prosecutorial capability to prosecute them criminally, but you can absolutely go after them civilly in federal court for every single one of those. So if you know the law and you can prove they broke the law, by all means, that's a cause of action.
That's what I want to throw in. That's what I was missing. Listen, Steve taught me a couple tricks where in his federal pleading, even though it's a case for civil damages, he invokes the impanelment of a grand jury. Not only invoke it, he asks for the arrest, imprisonment, or bailment of these people until this investigation is done. Because look, here's all the state and federal crimes they committed. Now, the chances of that happening probably slim, but it puts the fear of God into these people, because no longer is this a civil case for money damages. Now we're talking about people could possibly go to jail because
Yep.
you don't know what's going to happen. Maybe some federal prosecutor says, you know what? I'd like to ding one of these local people. I'll take this prosecution up. Hey, they just busted the tax collector down here, Ridley Township. She got busted for cheating on her own taxes. She got a year in jail and $120,000 fine.
Oh,
So that's the FBI coming over them, okay? So they don't know what's going to happen. When you put that in invocation for impoundment with a grand jury, it makes them nervous as hell because now they're thinking, oh, my God, I could possibly go to jail.
Well, yeah, and I doubled down on this, by the way, too, because it's in my complaint, right? It's in the introduction at the bottom of it. After my federal questions, I impaneled the grand jury. When I come back, right, well, so you have the Major Crimes Act of 18-something. It's for the Indians, by the way, okay? When the Indians are involved in criminal activity against non-tribe members, they are under the exclusive jurisdiction. So again, in my motion to strike, I brought it up. I demand that the court look into I can't do anything in federal court, right? But I can bring it up again that the assault of my body and my person and my life and my liberty and my property was an actual assault. That's what assault is, right? When you seized my free movement, when you stopped it, that's a seizure. I can't remember what case law that is, but it's a great case, by the way, because it explains it in great detail.
You can arrest.
Yes, that's right. It's at that moment, it's an arrest of freedom. Understand that, guys, and plead it correctly. All right. Anybody else got any?
We've got a whole bunch, honestly.
We do?
We had time to go through them all, but we've been talking for quite some time, and I think we probably need to take a break. So
let's see. I don't see anything of major importance. I'll tell you what, guys, what we'll do. We'll be back in Alphonse James 2 weeks. Give it a week.
Let's see. I should be 2 weeks. I should be good. Is that the first week of August?
Yeah, and I have I'm being invited. It's so crazy, folks. I'm being invited to talk at events here in Louisiana, right? So it just blows my mind. People want to hear me talk.
I got to tell you a funny story. So I take my wife out for ice cream the other night, right? So we go to this local ice cream shop and just standing there minding my own. And we're going out to leave, and I see this father and his son walk by, and he looks at me and he kind of looks at me like he's seen me or knows me. And I'm like, who the crap is this guy? He goes, are you James the Patriot? I'm like going, oh. My wife was like, your head just got this big.
Yeah, it's I've been lucky. I've got going on all these road trips. I've met a lot of people, and it's just amazing to me to see the people grow, to see y'all. Listen, guys. What you have here is a non-grifter set. Y'all got to understand this. We're not trying to fleece you of money. That's not what we're here to do. We don't want your money. We want these criminal actors' money. Okay? We're not here to grift you. We're not here to defraud you. We're here to give you all the information. And when it comes time, you're responsible. Okay? I can't do everything for you. You have to be responsible. And we'll give you all the tools to go forward. But it's not going to be like when I did my UCC thing, and I tried to do it years ago, and I contacted the guy, and I was like, by the way, what do I do now?
Yeah, what do I do now? Didn't work.
I don't know. What do you mean? You've got an irrevocable living trust, but what it's supposed to, I had questions. What is it supposed to do for me? Right?
How do I use it?
Yeah, you're in the private now. Well, how does anybody else know?
Well, okay, so like if I
treat me like I'm in a private,
Mr. Officer, I'm in the private. Yeah. He's gonna be like, well, put some freaking pants on. Let's go.
Yeah, let's just spell that right too. Listen, there's no public and private. Here's public and private. If I have a contract with Brandon, that nobody can interfere in that contract. As long as me and Brandon are not like trafficking women like sex slaves or something, it's a legal contract. Okay. If me and Brandon have a contract and it's all legal elements in there, no government entity can come in and interfere with that contract. That's what they talk about in the private. There's no such thing as you living among society and I'm living in the private in my own little cocoon walking around and you're in the public. No. You're interacting with the people. You're in the public too. That's not what the private and the public is. You're in the private when you contract with somebody. Otherwise, you're in the public. Okay.
Yeah. And that's the great thing. There is things to operate businesses in the private. I showed people the other day, Barnhart Crane and Rigging is a worldwide crane and rigging company. It is a private membership association. It is being done. There's people that do it. I believe, my personal opinion, I can't prove it because it's a private contract. I think the NFL is a private membership association too.
It's a membership association. Yeah, I actually know an ex-NFL player. It's a membership association.
Yeah, so they are operating, okay? So there's things that work out there that separate you. It's your creation, not the state's, okay? Just be mindful of that. But it has a charter, okay? So it has a rule of law, and that's the private contract that all the members agree to. First thing we don't talk about is that we rig the games here at the NFL. Second thing we don't talk about, we rig the games here at the NFL.
Listen, he's actually going to wind up suing him for the concussion protocol. Okay, and he's written the suit. Now, here's what the Players Association do with the NFL. Now, they're supposed to be counter adversaries, right? The Players Association and the NFL.
Yeah.
So the NFL set up a pool of money, and it's a very limited amount of money. So what they're trying to do is take the players, the ex-players. The Players Association is pushing these people to join the NFL's pool. Now, here's what they're doing. They didn't get in the pool, and the lawyers play games with them. They string them along hoping that they're going to die because they got concussion. So they're running the clock out on them. So he's the only one that said, I'm not joining the association. I'm going to deal with you in court. I'm going to sue your asses. And then I'm not in your game. But that's how corrupt it is. The Players Association is in bed with the NFL. Instead of an adversary, they're trying to bring people in to get this little small pool of money. That's how corrupt it is.
Great talk. I'll get with y'all. Like I said, I've got a few things next week. Very busy next week. Matter of fact, what I'll do is I'll contact y'all after the mediation, because if that's a good day, you know I'm going live. And so with that, I bid you adieu, brothers and sisters. I hope this blesses someone and ignites a fire within. We need more people standing. We just do. We need more people writing records requests, putting pressure on these people. We don't need any more complainers or whiners or excuse my language, bitches and moaners. We need people. We need people writing well-written complaints and putting the pressure on them. That's what we need.
Listen, in your mediation, Steve Emerson them, where you say, listen, if they're like bickering about, say, listen, I'll be happy to go to court. Who knows? Maybe I'll get $500,000 in this matter instead of 50. You know? My
daughter said, I made her write a one-page deal about how she felt, because that's all I need her to say there. I've already got everything ready. I'm going to slap these lawyers around, because it's not going to be anybody it's not going to be anybody from the hospital. It's just going to be lawyers. I'm about to slap them silly.
Yep.
All right,
hey, Brandon, real quick. People have been asking where they can find me. I'm on Telegram, guys. My channel is Affidavits. Affidavits 101 is my Telegram channel. That's the easiest way to find me. So I also have a website. It's the same, affidavits101.com. I started on this journey, listening to Alphonse and just soaking up all the information that he gave me. And I tend to retain things very well. So that's why I've kind of moved forward with that in my journey of teaching as many people as I can. But I've met people from all over this country, beautiful people, great people all over the place. And I will continue to do so. Like Brandon has said, and like Alphonse has said, I can't tell you how many times people have offered to pay me money. I've even got offers from people who are quote unquote, I wouldn't call them famous, but they've got a pretty good following on their podcasts and YouTube channels. They've even offered to pay me money, and I've turned them all down. I feel like I am on this planet at this time. God put me here so that I can use my ability to teach my brothers and sisters how we can retain our rights, our God-given rights, and we can get back what we've willfully given away because of our
listen, I want the money, but I'm not going to take it from the people that I'm helping.
I agree.
They got tons of it. I'm going to take it from them. That's where I'm getting it from. Okay?
I want to take the money from the real criminals who are actually acting like they're not the criminals. Does that make sense? I'm happy. Go ahead. I'll take a couple of, a 2 or a 3 with 7 zeros behind it. I'm okay with that.
I don't want to hear it's not about the money. It's always about the money. It better be about the money, because that's what's going to change their behavior. Because when a guy like Steve Emerson drops a $38.2 million suit on their head and they lose, well, the next guy that comes along in that situation, they may back off a little bit and go, hey, remember that guy?
Yeah.
Leave this guy alone, okay? And guess what?
You have to grasp this foundational truth. I don't care what happens to me. Okay, I really don't. It's the principle of a thing that keeps me driving forward. Until they rubber stamp that I'm an involuntary slave inside a courtroom and that I have no rights, I'm going to keep going forward. And that's so my adversary better understand my mindset on this. Okay, that I will not stop. I'm not going to stop. It's going to be appeals. I'll take it all the way to the Supreme Court. It doesn't matter. But what I do know is that the cost of these corporations, these business models, I know that is the one place to hit them and slap them and go take Tommy Tutu, the individual who violated my rights, make him have to pay me out of his paycheck every week. And guess what? I don't have to worry about that guy ever making that same mistake again.
Exactly. Money talks, guys. Money talks. And it's just like Alphonse said, I don't want your money. I want their money. So we just dropped a lawsuit against the Highway Patrol in Utah. My buddy, I wrote up that suit for him. And Brandon, you saw that lawsuit. I sent it over to you. And I would be shocked if they file, if they're stupid enough to file a 12B6 motion. Oh, I'm going to have some fun with that. But I really hope that they're not stupid enough, because there's mountains of evidence to show that they're in the wrong. So that's the advantage we have, you guys. That's the power we have, but only when we know how to do it. So.
Right. And you have to do it intelligently. It takes a little planning, right? And you're going to get better at these things. Listen, this is foreign to you. You don't know anything coming into this stuff. And this is why, listen, I love Dr. Graves. He's got the best course on earth for the cheapest price you could possibly pay. Yep. It's going to teach you something you've never learned. And I've got a lady I'm helping up that's been canceled by the woke culture up in defamed and slandered and everything else, death threats and everything else that's in it right now. I'm going to tell you, folks, take your time. Don't rush through it. Don't think that the first time you go through it, you got it. It's going to take 5 or 6 times. I still pull it up. I'll pull it up. I need to do a default judgment.
Steve references it.
Yeah. Let me go look at the default judgment section of it. Let me see. Okay, I got it. Now I know where to go. There's no way you can retain every bit of the information every day. It's impossible. Okay. It's amazing to me now. Learn to categorize information, right? Do work for me. What works for me, it doesn't work for everybody else. I categorize information and I attach it to something. That way I can pull it back out from memory, and it just works for me. I mean, that's how my mind works. I'm eccentric, very eccentric, close to being a nut job. Borderline. All right, guys. Hey, each and every one of you out there, we love you. I hope y'all enjoyed it. I hope it blesses you. James, thank you for coming on. Alphonse, it's always a pleasure, brother.
Look forward to the next one.
We'll catch you on the backside, brothers and sisters.